Second wife is receiving the pension in spite of the first wife. So earlier interim was not granted. We have filed industry service. So it may can be listed day after tomorrow,
Have it on Monday?
Monday.
Yes, my lord. In item number 52, my lord, I filed an affidavit, my lord. That may be called for, my lord.
Affidavit, then let it come on some other day.
My lord.
Let it come on some other day. You have
No, my
filed
lord, there is
it
some
by-
development in the matter, my lord. That transfer order has been modified. My lord, he has been posted to the same place where his wife is posted, my lord. Item 52. Yes.
Right. Get your affidavit.
Yes, but that may be disposed of, my lord.
Get your affidavit.
Yes, my lord.
May I please, your lordship, I beg to mention item number 30 of the daily list. Due to some difficulties, my senior has to leave early. The matter may be taken up on 23rd or 24th.
30,
Yes.
item 30, matter stands adjourned for a week. You're not fixing a date. Let it come after a week.
Bless.
Lordship, in this matter, Lordship, the respondent filed their affidavit in opposition yesterday, Lordship. So we need some time to file our reply, Lordship.
You filed it,
Yes, yes, no, 1405.
you submitted. But that the respondents have filed their affidavit yesterday. A copy of the same is not connected to the case report. Therefore, the matter be listed after 2 weeks,
4 weeks, Lordship,
4 weeks.
4 weeks, Lordship.
Instead, after 4 weeks, in the meantime, petitioners are at
What,
liberty to file
intimation?
their reply affidavit.
Interim order?
with vice-
My lord,
Lordship, interim order.
my lord, that is why, my lord, it should be 2 weeks, my lord, not 4. They are enjoying the interim, my lord, we file a affidavit. 2 weeks, my lord.
3 weeks. So that will
My-
give you 3 weeks.
Lordship.
Let the matter be listed again, 31st.
In the meantime, they may, my lord, file the reply.
Let it be on 7th of June.
Lordship. So
7th of June.
interim order will be.
Interim order passed earlier will continue to the next day.
Obliged, Lordship.
This case, in earlier occasion, is honorable director to receive instruction regarding communication dated 27, 7/2/2020.
Who is for the respondent?
Respondent, secondary education department.
Yeah. Any instruction?
Lordship, I'm appearing for the BTC.
The last date, government advocate was directed to take instruction with regard to the status of the proposal forwarded by the inspector to the director of pension.
Pension, case 33.
We have done, but,
Although government advocate was permitted to obtain instruction with regard to the status of proposal forwarded by the inspector. It has this circle, the director of pension. By the communication 27/3. And the matter was posted today. Let it happen. If Mr. Raghor, petitioner, any governor, pray for further time. Mr. Each of me. Let the matter be listed after 2 weeks.
2 weeks, my lord.
Instead of
That may be fixed,
31st. May.
Obliged.
Please, your lordship. The suspension order dated case 28, 27/1/2024, 3 months already is. Other Chaudhary case.
Will issue notice at this stage. Right? Will issue notice at this stage.
Instruction because.
Instruction is okay, you are praying for setting aside of the suspension.
Lordship.
You require
Beyond that,
them to file a response.
3 months and already.
That's okay, 3 months, Let them file their response. Heard? Yes. Weeks. Meanwhile, Mr. D. Bora is for
2 and 3.
respondents 23. Mr. Loco, respondent 1. Since the setting council. Since council three, the respondent wanted to go way now. It. It's open to everybody. It's instructed by the city.
It's a date yet, because it's a Gambura post, it's public is suffering here.
7th of June.
No, please, matter related to pension and withdrawal of access. Payment, and this is to notice me do money.
Heard the council to the. Mr. Bora, here's for. Who's for school education? Mr. D. Bora, here. Respondent 1. 3, 4, 3,
Respondent
Four.
4 only.
5, 6, 7. There is no standing council,
They have pending out elementary education.
but they're not here. There are board to the equal response. Since standing council is not present, vote pay. Mr. Bora. Mr. Bora, actually, yeah. 1, 3, 4, 5, 6, and 7. Extra copies be furnished to the other standing council. Then we have to do one week. This after. Let's get. Huh?
6 is same money. 6,
Similar. 5 and 6.
5 and 6, same money.
Okay, similar. 5 and 6.
Oblige me.
May please your lordship. See, dear, my senior was about to appear, but due to some difficulties, he's not able to arrive here. Lordship. Matter may be adjourned for time being, lordship. Another matter is also there, item number 15. lordship, to get.
Timing.
Matter relating to non-payment of retirement benefit, retirement gratuity and leave encashment. That's not.
For union,
File for AG, your lordship, for response of
use for the union,
you,
the sea surface repairs for water resources. Wrong for board also.
no, lordship.
Resort. And Mr. Rama. Sorry,
Boro.
A board,
R board.
R board, sorry. Here's for the.
Response of 4.
Report. They come in there. Steps of response number 1. 3, 5, 6, 7, 8. Be taken by usual course and registered post in the minute 1 week. And to be listed after the. Copy be furnished, standing out.
That will be applied.
Dates. Tenth of June. 10th June,
Also, revision challenge bar for disbursement of the retirement benefit, lordship.
tendency of the request be a part for this person.
Published.
Yes, yes.
My lord, there is no bar when a criminal trial is pending against a public servant, there is no bar in carrying on a disciplinary proceeding. But the disciplinary proceeding has to be an independent disciplinary proceeding with witnesses and evidence. My lord, here is a case, trial is going against me, and it is at the evidence stage in the trial court, and the disciplinary authority appoints an inquiry officer. He just calls the IO of the investigating officer of the trial case. He comes to before the inquiry officer and just reads over the charge sheet, he records it, and unilaterally he files a, my lord, inquiry report, my lord, without even giving opportunity. That is a different thing. My lord, here I am challenging this disciplinary proceeding, number one, and also I am under suspension for about 2 years, prolonged suspension. There are official guidelines when some trial or proceeding is going on, and after 3 months they have to review. They cannot routinely extend, my lord. Here they have also not done that. My lord, coming to the facts, my lord, I am a deputy superintendent of excise. 13/1/22, I was arrested. And when somebody is arrested and detained for more than 48 hours, automatically suspended. Naturally, my lord, I was also suspended. I got bail. Then, my lord, a charge sheet in the trial court was filed. I was given a so-called charge sheet in the trial court was filed. There in the trial court, trial commenced. Presently at the evidence stage, my lord, victim, informant, cross-examined, IO, and some others are to be examined. This is the position there. Now, my lord, in the proceeding, the presenting officer was appointed, IO was appointed, and only witness summoned was that IO of the trial. Neither the complainant of the case, nor the victim of the case, and no other material witness examined, no other document, my lord, produced, my lord, and if he files the inquiry report, lordship, my lord, first see the so-called notice, which is at page 40-41. Page 40. You are here required under 64 rules. Why penalties under Rule 7? Charge that while you were holding the post of Deputy Superintendent Excise Lakhimpur, you were arrested by the crime branch in connection with crime PS case number so-and-so under so-and-so Act. Arrested. Such conduct on your part as a government officer has tarnished the image of the government. You are therefore charged with misconduct. Now, question is here the imputation is I was arrested. I gave a reply to it, admitting that yes, it is a fact. I was arrested and then granted bail. I deny the charges. The arrest by itself, my lord, may not amount to misconduct, number one. Next page, lordship, page 41. Kindly see what is the statement of allegation. Page 41. On so-and-so date, so-and-so was arrested by so-and-so. That is the charge. Arrest itself is the charge, not the other thing, my lord. Other offenses, my lord, indeed. And list of witness, kindly see. Only witness, my lord, officer in charge. Crime branch, that is the, my lord, the investigating officer of the trial. And my lord, here, inquiry officer then submits a report unilaterally without even giving me opportunity to, my lord, cross-examination. The report, your lordship, will find at page 58. Page 58. Page 58, my lord, I was furnished the copy. It is a forwarding. And I was asked to make submission. Then coming to the report, my lord, at page 58. Page 62, lordship. 61 and 2, lordship may kindly see. 61. Here, your lordship will see statement of evidence of PW. Here, what is quoted? I so-and-so. Page 61, I am reading, my lord.
61.
Statement of evidence. Two witnesses, one was the crime branch and other the IO.
Yes.
Then, my lord, here, my lord, quote unquote, this is absolutely from the charge sheet. And PW2, it is first PW1, it tells about the arrest part, which is actually the imputation. Now, PW, the two, my lord, the investigating officer, he actually, my lord, reads about the charge sheet, and that is quote unquote recorded by the inquiry officer. That is the, and then 62, his assessment of the inquiry officer. PW2 stated about arrest. No material produced, not even any Xerox document of the trial, no evidence, my lord, adduced, no witness examined, victim informant not called. Well, my lord, this is, and then he writes, based on the materials on record on the evidence, misconduct is proved. So, this is, my lord, a mere, they made a mess of arrest and criminal charge against me. And one, well, if my lord, I am convicted, I am dismissed. You don't have to carry on a disciplinary proceeding there. But once you initiate a disciplinary proceeding, you cannot make it as an eyewash. It has to be fair, it has to be independent, witnesses will have to be brought. Suppose tomorrow I am acquitted there, then what happens? So, it cannot be an eyewash, my lord. It is like a summary proceeding. I am praying for that no follow-up to this, my lord, should be undertaken by them. And coming next, my lord, about the prolonged suspension, I was first suspended on, my lord, 3/9. When, my lord, I was under 48 hours of detention, subsequently the court granted bail. Then the suspension orders were annexed, my lord, the 67 in a routine manner. They are extending it. Every suspension order they extend by saying, whereas proceeding ground, page 67, lordship, same ditto. Whereas so-and-so, whereas proceeding ground up, does involve moral turpitude. Now it speaks about moral turpitude, my lord. Their so-called notice does not speak about moral turpitude. It says misconduct. I have shown to your lordship. It has been decided by the department to reinstatement. At this state may not be interest, cause embarrassment. So this is the same. Now, on by these word, particular word, embarrassment to the department. Well, every my lord delinquent once arrested. So this is how, my lord, it is extended, and the offense and the trial are not related to my official works. There is a
What is the status of the inquiry now? Completed.
inquiry report has given that.
So it is before the disciplinary authority.
The report has been furnished to me, inquiry report. Summary proceeding, one day. Summary proceeding. Let there be no follow-up. Then, my lord, the government guideline 77 about transfer. Page 77.
About suspension.
About, sorry, I'm suspension, Lord. This is also pursuant to a High Court's direction, and which was, my lord, laid down by the Supreme Court also, that the disciplinary authorities are strictly comply with the requirement of the charge before expiry of 3 months from the date of issuance. Second paragraph, last sentence. If the memorandum charge sheet is served within 3 months, it has been served on me, revision order must be passed, extension whenever necessary. Then next para. After issuance of memorandum of charge, the senior most secretaries shall undertake review within 6 months as regards desirability to further continue the suspension order. No review has been held, my lord, in my case. The extension orders, at least, they do not reflect. Secretary has to do, my lord, the senior most secretary has to undertake a review exercise, my lord. And I am now getting 75% of the salary, doing nothing. That is also not in public good. If I may submit, so your court.
Yeah.
So there is a case, my lord. 1992. This is a settled law. Number of this judgment has been followed.
You can tell us the citation.
99, volume 3. SCC 679. Yes.
Yes. Whole entity.
6, 7. Lordship, may straightway go to my lord paragraph 22 of the judgment. It, my lord, embodies the principles. Paragraph 22. The conclusion which are deducible from the various decisions of this court referred to above. Number 2 will be important. Yeah, it says one it says proceeding and proceeding criminal case simultaneously, there is no bar. Though separately. Second, Roman 2, if the departmental proceedings and the criminal case are based on identical and similar set of facts, and the charge in the criminal case against the delinquent employee is one of grave nature which involves complicated questions of law and fact, it would be desirable to stay the departmental proceeding till conclusion of the criminal. This I most respectfully, my lord.
Yes,
Please with your lord.
yes. What is the,
Lordship, I'll have to take instructions because the allegations are serious here, and the reason why petitioner got bail is on default by way of default bail. So nothing on merit has been
regular bail.
how does it matter?
The order says failure
No,
to
no, how does
submit.
it matter? He's on bail.
Yes, the fact remains that Lordship, it is a the nature of offense is serious.
Are you
Lordship.
saying that a bail will decide the correctness of criminal proceeding?
Even so, Lordship, the nature
on
of
bail.
offense is serious, Lordship. So I'll have to.
You're not challenging the bail order. He's on bail.
Lordship.
So your memorandum is there to decide
Because
how suspensions are to be reviewed.
I'll have to take instructions, Lordship.
Please do. Here, third learned, Mr. Borbora, AC Borbora, London City Council, State by
Issued by M. Smith.
and Mr. Rai Potakur, London Standing Council, Excise.
Excited.
Anyone else? Any other respondent?
No. SD, my lord, appointing.
This petition is filed by the commission, who is employed as a deputy, he's a deputy superintendent.
Yes.
Deputy superintendent. Excise. So, the petitioner was taken into custody pursuant to the higher court and was in custody for more than 48 hours. Subsequently, however, the petitioner was released on bail. So, since the petitioner was in custody for more than 48 hours, disciplinary proceedings have been initiated by Shweta Vashokos witnessing 16 September 2022 with the charges detailed in the Shweta. This petitioner was also placed under suspension. By which order?
Page 40.
Page 67.
Key. Or suspension order, 67.
67.
Suspension, no.
This is for continuation.
These are all continuous.
39. Sorry, Lordship, 39.
39.
Was placed under suspension with effect from 30/08/2022 ID order number 56/93/27.
48 hours custody.
Dated 3
Naturally.
Council for the pursuant to his arrest, pursuant to the investigation launch, due to the continued due to the after loading of the FIR, charge sheet was filed with the matter is presently under trial. Meanwhile, the department pursuant to the show cause proceeded with the departmental inquiry and very perfunctorily concluded the departmental inquiry and submitted, and the inquiry report was submitted to the disciplinary. Stop. That apart, the suspension of the petition has not been reviewed as is required by law, as well as the office memorandum dated 4th of February 2020. City Council, relying on the judgment of Captain M. Paul Anthony, court in instance, submits that while there is no bar for simultaneous continuance of disciplinary proceedings and criminal trial, however, where both the disciplinary proceedings and the criminal trial are based on the same and similar charges, it is advisable to stay the disciplinary proceedings still the conclusion of the criminal proceedings. He therefore submits that this writ petition be filed challenging the disciplinary proceedings as being contrary to the provisions of law by completing the proceedings with undue haste and the authorities ought to have kept in abeyance disciplinary proceedings during the trial which has proceeded against petitioner in crime branch PS case number 08 of 2020, the section 354/354A1 by C section 10 also. It is submitted that if the disciplinary proceeding is allowed to continue any further, there is apprehension of suffering grave injustice by the thereby the proceeding on its own was never undertaken by the department as per the provision of law. No witnesses were examined, only the statement of the IO was examined, and inquiry officer has submitted a report holding the petitioner guilty of all the charges against, holding the charges have been proved against. So, the matter is presented before the it is further submitted that as required under law, the review of the suspension petition has not been undertaken, and consequently, petitioner having been suspended for more than 90 days, its continuance of suspension is illegal and contrary. Sir, I border standing on the excise department submits that at this stage you have to complete, you require some time to complete the and finance it up. According to that notice be issued, Mr. represent the excise department. Notices of waived, however, extra will be furnished within a period of 1 week from today. Meanwhile, the next plenary day, the department of excise will not proceed to pass any final order on the inquiry report is submitted by the inquiry officer. So, the pendency of the writ petition shall not be a bar to review the suspension of the writ petition. Stop.
That
The-
aspect of negative, my lord, your lordship may consider looking at their response. Whether continuation of the suspension is
Argument
justified.
made in the writ petition will be considered upon the reply being filed by the writ petitioner on the next day. This again on
Lordship.
10th of June.
Oblige, lordship. Thanks. That would be very fixable. Lordship. Oblige.
Yes.
Well, the petitioner is serving as an assistant sub-inspector ministerial in the Central Reserve Police Force, presently posted at Composite Hospital, Silchar.
And Lordship, at page 12, by order dated 2/3/2024, he was transferred to a battalion in Tripura, my lord. 140 battalion, Tripura, Lordship will find it page 12. The allotted unit in the tabular part, Lordship will find it 140 battalion. That is located at Tripura, my lord. Now, my lord, on receipt of the transfer order, he preferred an application, page 13 onwards, Lordship will find at page 14, my lord. His wife, my lord, he was posted to Composite Silchar on the ground that his wife and he was trying to go for infertility treatment. And my lord, his wife was pregnant at that time and he had moved this application at page, my lord, 14. Lordship will find at the top line, my lord, prolonged treatment and various difficulties we were content, and the wife of the applicant is on a last stage of her pregnancy, and as such, she is unable to work, and as per the advice of the doctor, she is on bed rest and needs to be availed treatment for one next year. Then Lordship will find at paragraph 2, I reside with my wife and father who is 87 years of age and unable to work due to his old age treatment. Therefore, at page 15, my lord, he had asked for a consideration for posting at Group Center Silchar, 147 battalion, range office Silchar, CIT, or my lord at 5, a retention for 1 year. At that stage, my lord, at page 21, by order dated 23/2024, the application was rejected. Page 21, my lord. By order dated 28/3/2024, the application was rejected. In the meantime, my lord, he was blessed with a son. And there were complications in the pregnancy. At page 23, Lordship will find the doctor has certified that his wife is under the treatment of doctor for pregnancy and delivery and probable DVT, for which the patient is advised to remain under supervision for 6 months period.
What is
My my lord, it is called deep vein thrombosis due to the medicines which were given to the wife for the infertility treatment, and my lord, there is a possibility that there may be blood clots in her vein, which may lead to very much complications. The only prayer today is, my lord, if they have a reconsideration of my case for retention for 6 months or a year, either, my lord, I can make arrangements to have my wife attended, because I only have my 87-year-old father and my wife with a 20-day-old child. At this stage, my lord, if they reconsider the situation,
Yes.
come to a conclusion.
Lordship,
Just worsen that.
earlier, no, Lordship, Lordship,
Human problem.
Lordship, no, Lordship, earlier his representation was considered by the authorities, Lordship, and on merit after consideration of his case, Lordship, it was rejected.
We don't know what is the merit, but you have rejected it, yes.
Rejected, Lordship, and he, since 2012, Lordship, he in the Homestead Assam, Lordship. And now also his first posting is in Silchar. And
You're not addressing the questions of the court. He has raised a pertinent, is a medical problem. Now,
Lordship,
you may refer the case of the wife to the group medical center and get an opinion and find out whether he's correct or he's exaggerating. So all these exercise you'll have to undertake. You can't say we rejected it on merit. Where is the merit? How have you decided the
Lordship,
merit?
as per the standing order 2004.
Standing order is okay,
No,
but are you
Lordship.
suggesting that as members of discipline force, your responsibility towards your family members?
Lordship, as per the medical certificate, there is no such serious medical condition, Lordship. It is probable cause of DVT.
No, where have you, on what basis are you making this statement?
Lordship, this is a medical certificate of 23.
That's right. So whether it is serious or not, how do you know? He's been advised to remain under supervision for 6 months
Lordship,
by the treating doctor. Where is the treating doctor?
Lordship, in Tripura also, Lordship, there is
In Silchar.
Silchar itself. The difficulty is, my lord, my 20-day-old child with my 87-year-old father, my wife being under supervision all the time.
Lordship in Tripura where
The whole family.
he is transferred, Lordship. And there also there are adequate medical facility to treat his
That's right.
wife, Lordship.
We are
Lordship,
not asking you to, we are not undermining your difficulty,
Lordship.
but you have rejected it. Your order of rejection does not
Say anything.
disclose any reasons. Why? must be there in the file, but it is not here. So if you think that this is a medical disorder which can be treated in Tripura or there are facilities there, give the reason.
Lordship, as per understanding under the medical grounds, on medical grounds, retentions can be permissible only on some specific Lordship ailments like cancer, paralytic, stroke, renal failure, etc. Lordship.
But medical problems are
Yes.
medical problems. This may not be one of the conditions which was before the authorities while framing the criteria.
Lordship.
So you'll have to take a proper
These are the Lordship,
view of the,
common grounds, Lordship, for stay of this transfer order, Lordship.
let the authority say that. Are
Yes.
you on instructions to say so?
Lordship, as per my instruction, Lordship, since 2012, he is in his home state, Lordship.
Right, you
And-
consider it. You take a, either you get your instructions on this,
Lordship, yes, Lordship,
you get your instructions on this.
on Monday, Lordship. Till that,
Monday,
no,
Tuesday, whenever that you want.
Lordship.
Third Learned Council departments. The
But interim may not be granted, Lordship, till that.
petitioner is for this court. Challenging the, where is the transfer order?
My lord, that transfer order is at page 15, 12.
Challenging the transfer order dated 2024 whereby he was posted from his present posting to 140 battalion stationed in Tripura. Tripura. Petitioner is aggrieved by the petitioner is aggrieved by the petitioner represented to the authority requesting for reconsideration of the order view of the medical ailment suffered by his wife due to pregnancy and delivery of a newborn baby, as well as his, 87-year-old father.
Father, my lord.
with
Doesn't have a
old
mother.
age ailments. So this representation came to be rejected by the authority. Petitioner is agreed by the order and before the court for direction to the respondents to reconsider his prayer for extension, retention, same day to posting, or posting at or giving posting at the options reflected in his representation was filed to the authority. What is the date?
The representation,
What is the date?
the representation 4/3/2024, my lord.
Representation dated 4/3.
At page 17 below the signature, 4/3/24.
4/3. Are they will CC? That you'd like to obtain required. With the matter be listed again on
Monday, Lordship.
Monday, 20. Till the next date,
Lordship, interim,
the transfer order dated 3/2024 shall not be given effect to so far as the written date. Till Monday,
Monday, Lordship.
Obliged, my lord.
you may furnish the extra copies.
May I please your lordship, my senior is laying in another court. Kindly pass the matter for timely.
May please, your lordship. Lordship, petitioner for lordship was an admittedly lordship a Maksurul worker, lordship, and his regularization has been dropped. As his name was not sent due to oversight. Lordship will peruse page 43. In Excel 6, lordship. Yeah,
Page number
43, lordship.
43.
The original type copy is at lordship page 40, lordship. Type copy at page 40.
Yes.
Yes, Lordship. In the right side column, Lordship, the incumbent concerned Sri Gozendas, that is the petitioner, was engaged as MR worker with effect from 12/12/82 under Borlia Division Irrigation Town Code, but he was not regularized as per Gate 4 as his name was dropped on the MR list, though through oversight at the time of regularization of because of the lessons on the part of respondent authorities, Lordship, the service of the petitioner could not be regularized. And thereafter, Lordship, the petitioner submitted several representations. And before that, also, the petitioner has approached the respondent authorities for regulation of his service. And there,
Will issue notice that it's the third council. The petitioner was working as casual labor. The office of the executive and for a couple of investigation division. Yeah. Subsequently, he was appointed as the day officer. ID order number 08, which came extended. Petitioner services were altered from casual employee to master role employee since 1999. And since then, the petitioner working spite of his education for regularized. The petitioner's case not been taken up for consideration for regularized. Subsequently, he superannuated on 31/12 without being regularized. And consequently, petitioner was denied his pensionary benefit, being aggrieved with the process. MS RB Bora, and also PTC.
Yes, Lordship, for 7, 8, 9, 13 and 14.
Respondent 7, 8, 9.
13 and 14.
Mr. N05, right?
I am for 4, 5, 10 and 11.
Respondent 4, 5, 10 and 11.
Lost.
Mr. A Bora 4, B Bora 4,
he put up for 1 and 50.
1 and 50. H Sharma 4, respondent 6. 6. Mr. Borpuzari for respondent 2.
2 and 3.
Huh?
2 and 3.
2 and 3. Anyone else? Anyone else?
No, Lordship. I have.
Let the notice be issued written about 4 weeks. Notices the way of you know 1 week.
I'm lost. I am for 12 also. Lost. Obliged.
With the matter. Instead after the technical date. Extra copies be furnished. Standing within a period of 1 week.
Obviously.
Right, Your Lordship. My lord, we have challenged partially the order. Mr. Lordship may kindly see page 36. There, my lord, there is a dispute regarding the seniority matter. And earlier, the present petitioner approached this Honorable High Court claiming that I am the senior most teacher as per the seniority list prepared by the IS BDC, Bongaigaon District Circle. Then this Honorable High Court passed order to decide the matter by the director. After hearing both the parties, director passed the order, that is page 36. Here, regarding other portion, I have no objection, but page 37, Lordship may kindly see.
30?
37. Last three, therefore, Lordship has seen. Therefore, the inspector of schools BDC Bongaigaon is hereby directed to revisit the order number so dated 1/2/23 issued from her office immediately and recover the excess drawal amount, if any, from Srimati Sundarani Medhi, assistant teacher of Abhaypuri SS and MP school, Bongaigaon immediately. So, my lord, excess drawal of amount that was not on the basis of my seniority. That was given on the basis of with passing B.Ed examination. Lordship may kindly say as 18. That is my B.Ed degree certificate.
No, by this order, what was directed?
Directed to recover the excess dwell. Excess dwell means, my lord, now Lordship may kindly see what is excess, they understand. It is not clear by the director letter what excess amount I have drawn up. Yes, 38 kindly see.
Where is the, yes, where is the order? Uh. of-
1/12/2019, yes,
One-
that is page 38.
Ah,
In pursuance of Government of Assam Finance Research and Department, Dispur Guwahati by number so and so, that is the following teacher of Obhaipuri SSMP school under BDC Bongaigaon is hereby allowed to draw grade pay of rupees 8,700 as trained graduate teacher from the date of effect shown against the name of the incumbent.
You were
Sundarani
you
Miti.
were appointed as in charge headmaster,
I was in charge principal, I was
in charge principal.
academic in charge.
Academy.
Actually, principal in charge was appointed was Sanjay Kolita. I challenged his appointment.
Hmm.
But director found that he is senior to me, and that's why director did not allow me to hold the charge. Even then, till today, I am holding the academic in charge. That is another matter.
So
But thing is this,
did you hold any charge of in charge principal?
academic in charge, no, as in charge principal, I did not hold. Now, my grade pay has been given due to passing, being a trained teacher. That trained teacher due to passing B.Ed examination. That is was 18 by.
But the order does not say that excess royal in respect of grade pay is to be withdrawn or is to be
It is
recovered.
not said, but thing is this now, the IS Bongaigaon is trying to deduct the said amount which I have drawn up from the day of issuing this order,
It says excess royal, if any,
if any.
if any.
If.
It does not say that excess royal has to be recovered. It
But-
said excess royal, if any.
If any, but if any, it is meant by IS that I have drawn up the graduate, this 8,700 from 1/12/2019 as per order of IS, these and IS, page 38. So I have got that excess, what they mean excess or grade pay as per order of IS due to
So
passing.
you have not read the effective paragraph. The paragraph above that. Government notification dated 4/4,
Yes,
4/8.
yes.
That is the paragraph. which you have read.
No, it is whole that I was an intermediate teacher at that time.
No. It
But-
says that this amount of grade pay
Yes.
was allowed with retrospective effect without approval of the government. Therefore, that amount is found to be against the rules and
No,
sought to be recovered. That is what the paragraph.
no, actually, Lordship may kindly see page 38. The IS has passed the order quoting the finance department's order. In pursuance of the government of Assam Finance, Pay Research
I don't know that.
Unit
Yes,
Department.
Yes, Mr. Attorney.
Yes, no, this is the answer, my lord. The government notification that this pertains to Director of Elementary Education, my lord. In case of trained graduate teachers of ME, MB and senior basic school under the Director of Elementary Education, then only that grade pay is allowed to draw, my lord. But the petitioner is a graduate teacher, intermediate teacher of my lord, secondary school, my lord.
No, I am graduate teacher. Earlier I was the intermediate teacher.
Subsequently,
since 2018
subsequently she acquired graduate degree, my lord. Subsequently, she acquired graduate
Your,
degree.
your appointment status is that of an intermediate.
Intermediate.
Intermediate earlier. Thereafter I passed B.Ed examination, BA examination. But after BA examination, I was paid nothing. But after passing B.Ed examination, being a trained teacher,
You are saying that this notification is related to
Elementary education.
Heard.
that is not clear, but for the time being, my lord, this may kindly be stayed. Otherwise, I will suffer heavy financial loss.
Dated 27/3/2024, in the Director of Secretary Education, whereby it was directed that the Inspector of School, DTC, Bongaigaon was to revisit the order number so and so dated 1/2/2023 issued from the office of the inspector of school and recover excess royal amount if any from the expedition. So by the order dated one earlier by order dated 1/2/2023, the inspector of schools PTC Bongaigaon had allowed the petitioner to draw grade pay of 8700 per month as trained graduate teacher. So in the same order, reference notification number FPC dot 04/2018/136 dated 4/8/2018 was quoted. Internal counsel for the petitioner argues that the grade pay of rupees 8700 was allowed to be drawn by the petitioner as the petitioner is a trained graduate and has completed her BA.
Yes.
Therefore, under the provisions of law, the petitioner is entitled for royal of grade pay of 8700 per month. Stop. However, the direction of the director to revisit the order and recover any excess royal by petitioner is contrary to the provision of law and therefore same is required to be interpreted and set aside. So, Mr. N.J. Katonian, standing counsel, the other end submits that the notification dated 4/8/2018 quoted in the order dated 1/2/2023 permitting the writ petitioner allowing the writ petitioner permitting the writ petitioner to draw excess grade pay 8700 per month pertains to the Department of Elementary Education. The petitioner is an employee under the Department of School Education.
Secondary education.
Secondary. And accordingly, there appears to be no infirmity in the order of the director dated 27/3/2024, directing the inspector of schools, Bongaigaon PTC Bongaigaon, to recover excess payment, excess royal amount from the petition, as the same did not have the approval of the appropriate, did not have the approval of the government, and is in violation. So he, however, submits that he would like to complete the instruction and apprise the court. Accordingly, then we should return to court. The standing counsel, standing counsel.
For all the respondents.
All the respondent notices of way, however, the court is furnished within a period of 1 week. The matter be listed after the return date in the next day fixed. No recovery of any excess amount which may have been brought by the petition shall be undertaken by the inspector of schools pursuant to the order dated 27/3/2024 passed by the director.
Highly obliged.
10th of June.
Obliged.
May I please your lordship?
Yes.
Matter relating to pensioner benefit lordship. It is
Let notice go, my lord, at this stage.
Will issue notice?
My lordship, already similar situated person case has been disposed by this honorable High Court lordship, Annexure 10 lordship, page 30 lordship. It is also covered case lordship.
My lord, the thing is that factual thing has to be, my lord, ascertained. That is why, my lord, I'm saying for notice, my lord.
You'll have it on Friday, you go through. Find out. No,
My lord, instruction is required, my lord.
all right. Then we'll not issue notice. You get your instruction.
My lord,
We'll give you a week's time.
10 days time, my lord.
But, uh, right. Pensionary benefits. Pensioner, for long 24 years. PW as master loan partner without break. The petitioner's husband. And here, and after regularization, he served for 7 years, 9 months. So, the husband of the petitioner not receiving by expired or not. When did he expire? When did he expire?
Lordship. Lordship 1/11/2020, Lordship. Annex 9, Lordship.
He expired on March 11th. How pension is submitted by the current company. The petition that similar petition is put up by more than 25. Asking the rates for a simple that the R or that is permitted to obtain instruction. 31st.
My lord.
31st.
My lord.
I level it.
And 15, my lord, same, my lord. It is not before lordship, my lord.
You are addressing which matter? 15 or 7?
7.
7.
My lord, petitioner for lordship is challenge, my lord, the the condition of the appointment, my lord, of the petitioner, my lord. $199, my lord. Page 180, my lord. My lord. This was issued on 30 January 2021, my lord. He was there accommodated teacher by giving scale, but they are completed in basic training in 13,593, my lord. But they did not, my lord, as a stipendary teacher, my lord. And we challenge this condition, my lord, put, my lord. Case, my lord. 180, my lord. The post against which appointed accommodated as a teacher is purely personal nature within the source. Next, my lord. Before that, my lord. Deputy Inspector of School District Elementary Education Officer concerned with Insuket prospective effect with 1/11/2020, my lord. And second paragraph, second page, my lord, 181. The accommodated teacher will get a prospective effect from the 1/11/2020 only, and she claim any benefit whatsoever in respect of past service rendered by him prior to 1/11/2020, my lord. Prior, my lord, that condition is I'm going to tell in, my lord. And your lordship, my lord, already, my lord, similar matter was your lordship is to notice, my lord. Lordship notice may go, my lord.
Heard. Yes.
Yes, ma'am.
Heard. Okay. Mr. Red, take up here. Okay. Response. 3, 4, 5. There are board of the response. Let's say. Please carry on to the response. Okay, now, finished within a week. Be listed after return.
My lord, next is also same.
Item number 15.
15, man. Same celebrity for a program.
Here, what is the order?
Minus next
75.
75, my lord, 75.
Which part?
Minus space 76, my lord.
76.
70.
Same order.
Right.
Same respondent?
Then no spend, my lord. Yes, my lord.
Yes, sir.
Similar select list, my lord. This one order was passed by the my lord justice.
By this court.
Huh?
Yes.
My lord, same already, they also complied with it. Much.
Wait, please, Your Lordship. It's a matter relates to non-payment of pensionary benefit. The petitioner retired from his services on 30th of June 2021. But till date, the pension and other retirement benefits has not been paid.
Yes.
Yeah, Lordship, Mr. Ardhar, he was here. He just said a matter in court number 1.
Right.
Same.
Is this petition filed to this petitioner claiming that pension petitioner served as a section assistant, work charge employee.
The section,
There's a section assistant, served as a section assistant. The office of the executive. Media. The services of the petitioner was particular catered against a vacant sanction post. And he was confirmed on 4/12/2020. In retrospect. Petitioners were admitted on 3/006/2021. Although stop although we submitted in pension statement, same and petitioner direction notice written week hardcore. On behalf of this one. It's at 6/1/20, the D Bora. Correspondent number
And 7.
7, MS.
Respondent for article of the nation.
Window for architecture appears on behalf of respondent number 4 and 5. 4 and 5. Standing down to represent the respondent to the main lecture of the condition. 1 week from notification after.
hello.
Yes, yes.
May be before. Lordship. My lord, consequential service benefit, my lord. Date of retirement 30/11/1996, my lord.
Right, we'll issue notice here.
Well, in fact, my lord, the losses transfer to cost title. One thing is there is a delay. I am not on delay, my lord. If a losses transfer to cost title, even the parent department and the GMC is not a party because it will be difficult on the later on if any order passed, my lord. Because the parent department, Department of Housing and Urban Affairs is not the party. Even GMC is not the party. Only officials of GMC are party.
You have to make DMC.
Respondent number 1, my lord, commissioner.
No, no,
No, no.
Here, he can't represent state of Assam. You look at respondent number 1. Who have you
Yes,
arrayed?
commissioner. That is also.
Who have you arrayed as respondent 1?
Cannot be. GMC commissioner cannot represent the state of Assam.
Who is respondent 1?
1 is the head of the department.
What is, how have you represented? Kindly read. Respondent 1?
It will be separated, my lord.
Huh?
Separated.
You can
Commissioner
make
got it.
corrections. You make corrections.
Yes, yes, my lord, I may be allowed.
We will allow you to withdraw and file a fresh one. Corrected it.
No, for amended post title, I will finish, my lord.
This amended post title will take a long time to correct it.
Department of Housing and Urban Affairs is not a party. GMC is not a party.
State can't be represented by commission.
Yes,
DMC.
my lord, I have not checked, my lord.
This is the hazard of a busy lawyer. If you're busy, then you don't get to check. We can allow you to correct it, but I think it would be better if you withdraw and file afresh, make all the necessary correction.
All right.
Right?
All right.
Mr. N.K. Murray permitted to withdraw his petition with liberty to file as he submits that certain corrections are necessary in the post title.
My lord, that may be reflected, my lord.
Whatever corrections you want, you put it. Why do you want to ask to reflect? They're giving you liberty to refile. Mr. S. Bora appeals for PSC, Mr. D. Bhattacharya for record.
With liberty, my lord.
Yes, it's with liberty.
Applies. me.
I'm here for art.
Mr. R. Porphyry for respondent. Mr. Bora for respondent. You file it afresh.
Yes, yes.
Well, here in this case, the petitioner was appointed as a stipendiary teacher in the on 9/2/1996, and she joined on 9/2/1996. And appointment letter was issued on 30/1/96. Appointment letter, your lordship will find at page 12. And earlier, she approached this honorable court. That, honorable court was pleased to dispose of the petition, madam. Lordship will find page 16. Earlier order, man. Page 15, the operating part is that directed the respondents to verify that the appointment, petitioner shall furnish certificate copy of this order, and respondent or concerned doing needful. Thereafter, an order was passed. Lordship will find that page 18, but the date wrongly mentioned. Perhaps it is pursuant to this order. Annexure 4 was passed by the Deputy Inspector of Schools. Here, wrongly date is mentioned as 31/3/2001.
Yes.
Well, she has not been paid any stipend till today. He approached the authority. I have submitted representations also. Earlier also, another petition, another petitioner approached this honorable court. In that case, this honorable court was pleased to issue notice.
Matter is pending.
Yes, my lord.
We'll issue notice here.
My lord.
But Mr. Politana.
And both the matter may come together also.
In the Katunia hearing for respondent number 2, 3, 4, 5, 6, and Mr. D. Bora for respondent. You should notice that the standing counsel representative respondent is the way power action. Within 1 week. These are similar matters.
Yes, madam.
Matter be submitted that there's a similar matter already pending with this court. And counsel for the petition that this matter be listed along with the 6 8 both these petitions be listed together after that will take.
Obligation.
Obligation.
Yes, what happened to the state? Who's for the state? Mojumdar. Please inform him, we'll take it up at 2. Yes.
I may be allowed to R Muzumdar, Your Lordship.
Yes, call him, we'll take it up at 2 p.m. 2 p.m.
Yes, please, Lordship. Well, here the petitioners retired from service and his provisional pension and other pension not released, my lord. He was suspended by annexure E page 45 and later on page 55, he was reinstated in his service and retired as a regular headmaster. The DP has concluded, my lord. DP says that punishment censory. Now, this page 56 annexure H, this is the DP, my lord, order. DP is concluded. Only punishment given censory. Now, only what is the
Censure.
censure? Yes. But this said that, my lord, page 57, the period during the suspension, this 75% is given, that is his entitlement, rest 25 is not his entitlement. So, my lord, he is agreed by that, because if there is, there is second notice should be given that that punishment should be given. So, secondly, my lord, the provisional pension, this not released, my lord, page 72, annexure
We
Q.
issue notice here.
Yes.
We'll issue notice.
Regarding provisional pension, my lord, your lordship may direct, my lord, because page 72, it says that without audit report also, the provisional pension can be released, my lord. There is a notification from the government, page 72, annexure Q.
Yes, yes. Heard.
Yes. So he is without any penny for last 4.
Issue notice. About 4 weeks. Study. Okay. Contents 1, 2, 3. Steps taken by registered post office 4 within 1 week. Pendency of the petition shall not be a bar to please the process and the provisional.
Provisional.
That will be listed up. It's a standing offer. This notices extra copies be furnished within 1 week. Today.
Lodge.
My lord, on last occasion also, nobody appeared. No.
This is about
My lord, in fact, they are employees of a particular, my lord, cooperative bank, Guwahati Town Cooperative Bank. Now, that was put under liquidation, and subsequently, my lord, they have filed this application for grant of VRS. Now, this VRS proposal has been rejected by the government. That is not under challenge. And more so, my lord, I have placed a judgment of the division bench in Writ Appeal 5, which says, my lord, that they are not government employees, so they cannot claim any financial aid, my lord, from the government. Whatever, my lord, their claim is, which will be confined to, my lord, the bank itself.
since none appears, so there is general. Mr. S.K. Thakur appears of the hospital. None is represented the petition of 16/11/2020, 23/2024, 10/5/2024. From accordingly, the petitions are dismissed for non-prosecution in the order in the next advocate.
Deeply obliged.
Call for Mr. KL. Yes, you are here.
Lordship,
Huh?
I've got 21, 22,
Yes.
21, 22, 23, 24. We have filed our affidavit, Lord.
Who's for the petition?
So Goenka is there.
148.
148, Lord.
Where is it going now?
Nobody is there, Lord.
Is it alive? This
That's
matter is still alive?
that I think, Lordship, probably they may not, because after that Supreme Court judgment in Ashish Agarwal case, probably
What is the citation?
Lordship for 2021, Ashish Agarwal. Lordship make fix the matter on next week. I'll open instruction and I'll also inform Mr.
You,
Guntur.
you give us the judgment, we'll take it up at 2
Yes.
p.m. 2 p.m.
I'll watch.
At 2. Pull up at
Up to 24 years,
25. I think.
25.
25. Yes. And for the petition,
On several occasions, my lord, the petitioner has been,
unappealed,
even my lord, already my lord, petitioner has get relief, my lord.
3/5/2024, it's 5. Accordingly, this one. The 24 appeals for the respondent.
NCL, sir.
Hence,
Diploma.
Yes, please, Your Lordship. Lordship, I'm appearing on behalf of Mr. S. Bani. An adjournment slip has already been given. Lordship, I pray,
in
any
terms
other
of the
day.
adjournment slip circulated, matter stands adjourned. Two weeks. Yeah.
Obliged.
Mr. Bora and Mr. Jari.
2 and 5.
Yes,
Will not discuss it, become impact of.
it's submitted by Mr. S. Das. the deputy According to it, it's dismissed. The conference. The headings are located with the name of the it is for respondent accountant general. Yes.
I feel for respondent.
Mr. D. Bora for
Your Lordship. Now need phone number 2.
yes.
Okay.
Mr. R. Borpudari for finance.
May it please your lordships. My lord, this petitioner is lecturer senior scale lordships. And lordships, she has filed the application for getting lecturer selection grade lordships. As she is eligible as per office memorandum dated 17/1/2018 lordships. And lordship, this respondent as on today lordship, no affidavit is filed lordships. The matter is of 2016, 2021, and the petitioner is 59 years old. Next year, she is retiring lordships.
Where is that notification on which you are?
Lordships.
taking-
Page 28 lordship. Annexure 2. Relevant page 29 lordships. 29. A 2.6 lordships.
Yes.
Lordships, this petitioner is BE, not ME lordships. Lecturer who do not have PhD or a master degree in the relevant branch, discipline of a program shall be eligible for the AGP of rupees 7,000 only after completion of 9 years service as lecturer Lordships, that AGP of 7,000 I am getting, Lordships. Then Lordships, A 2.9, Lordships, below it, lecturers with completed service of 5 years with AGP of 7 years shall be eligible subject to other requirement. Clause A 2.13 laid down by the AICT to move to the AGP of 8,000. Lordships, this 8,000 I am entitled to get. As on now, Lordships, I have not get the AGP of rupees 8,000. Lordships, next page 30, Lordships, A 2.12, Lordships. Lecturer selection grade completing 3 years of teaching with the AGP of rupees 8,000 shall be eligible subject to other conditions. Clause A 2.13 as prescribed by the AICTM to move to the pay band of rupees 37,400 to 67,000 with AGP of 9,000. Lordships, here this scale I am entitled, Lordships. And Lordships, A 2.13, all adva
2.9 also you have received.
Two-
2.9,
2.9, Lordship, that I have not received, Lord.
you have not received.
Not received. I have received only
2.6,
AGP 7,000,
2.6,
2.6, Lordship.
yes.
2.8 I have not got. I am entitled. Then A 2.12, Lordships. Then A 2.13. All advancement to higher grade pay in various cadres will be affected subject to completion of 2 AICT approved refresher program, short-term course of not less than 2 weeks duration and 1 week each TEQIP sponsored program or 1 week each AICTE, UGC, MHRD, DST, Center State Universities Institute short-term program as per declaration in the AICT notification dated so and so 14/1/2016 and so and so dated 9/6/2016. 2. Satisfactory annual confidential report for the last 3 years. Lordship, last 3 years there is a satisfactory annual confidential report, Lordship, and also Lordships. This accordingly, Lordships, page 44, Lordships. Page 44, the principal Assam Engineering Institute, Lordship, wrote a letter, Lordships, to the Director of Technical Education, Assam. There in this, Lordships, my name is also forwarded, including others, Lordships. Below, Lordships, one is Mokaddas Hussain, next is Mousumi Lahon, third is Oloka Das, that is myself, Lordships, and fourth Swapnali Bora, Lordship. Other 3 Lordship, they have got the that benefit, Lordships. Lecturer selection grade, Lordships, including AGP of 8,000 and 9,000, Lordship, whereas I am deprived of. And accordingly, Lordships, I have approached before reasonable court, Lordships.
Have you represented before the authority?
Lordships, Lordship, subsequently, Lordship, I have submitted the application, Lordship, page 46, Lordship. I have annexure 6, Lordship. I have written a letter to the Joint Secretary.
So what,
Nothing is communicated, Lordship. Here, Lordships, I have approached prayer for upgradation of grade pay of rupees 7,000 to higher grade pay of 8,000 and granting of all consequential benefit under CAS. Lordships, this representation, it was submitted on 28/12/2020, Lordships. And Lordship, there is no response, Lordships. And Lordship, subsequently also, Lordships, one letter was submitted before the Honorable Education Minister, page 47, Lordship.
yes, we have seen that. Yes, Mr. Gogoi, what do you say?
Lordship, today handicap 10 days time may be given, Lordship. I am taking the second file, Lordship.
So Lordship, 10 days time may be given, I will come out with a definite instruction, Lordship. Whether that was not given. Otherwise also some issues decided by honorable single bench and division bench, whether that matter will be covered it or not, Lordship, I will place it, Lordship.
Lordship, next year I am retiring.
That 10 days time I am have to.
10 days.
10 days, okay,
Lordship.
10 days.
I'll that of the thing satisfying the requirement. The petitioner who's serving as a lecturer, Assam Engineering Institute
Lordships.
has been wrongfully denied her claim of higher grade pay. Now, what is that?
Lecturer selection grade.
Lecturer selection. In spite of satisfying all the criteria. The representation to the government has also not yielded any response. Although the petition has been filed in the year 2021 after affidavit. Mr. T. Goy, Study Council, Higher Education, submits that he would like to respond to the claims made by the petitioner. He prays for accommodation for 10 days.
Lordship.
Prayer made is not objected to by the Council of the Petitioner. Accordingly, this court considers it appropriate to grant 10 days further time to the respondent to complete his instructions. Stop. It is made clear by the next date, if no instructions are forthcoming, the court will proceed to decide the matter on the basis of the pleadings available on this ground. This again on 31st. 31st May.
I know.
Happy proceed. In this case, my lord, the petitioner has filed this petition before this honorable court, my lord, answer 14 for modification of this order, lordship.
Just 1 minute.
49.
Yes.
My lord, page 49 kindly the lordship.
14?
49, 49. This is order, lordship. My lord, extraordinary leave without pay on medical ground for 272 days with effect from 1/12/2011 to 28/8/2012 is hereby granted to Sri Abdur Rahim, Assamese language teacher of Pratapgarh Public High School in Pinokhal, Karimganj under Rule 14(2) and 15(1) of revised league rules 1934. My lord, prior to this, lordship, kindly see page 37, lordship. My lord, 35, connection 9.
Yes.
Abdur Rahim, ALT, Pratapgarh Public High School, Karimganj is present. The inspector of schools and the headmistress of the school did not attend despite being informed to attend. Heard Abdur Rahim, again, I hereby order that Sri Abdur Rahim be sanctioned special leave for TB on medical certificate for 1/7/2020, 2010 to 39/2010, 3 months. 1/10/2010 to 30/11/2010, 2 months. 1/4/2011 to 30/11/2011, 8 months, subject to production of medical certificate. He claims to have resumed duties 1/12/2011, but was allowed to sign attendance on 27/8/2012. His claim for salary from 1/12/2011 to 26/11 26/8/2012 cannot be accepted, Lordship. And the inspector of schools, Karimganj, is directed to take steps for sanction of leave after exhausting his earned leave. The grievances, Lordship, here is this period of my lord was exhausted with earned leave, Lord. It is not permitted, Lordship. On the other hand, my lord, I was not allowed to, my lord, sign in the attendance register with effect from 1/12/2011 to 26/8/2012. My lord, this is my lord, I did not allowed to sign, my lord, my salary was not paid, Lordship. Then, my lord, this was challenged, my lord, before this honorable court, Lordship. And we see at page 38.
What was the order path?
Order passed, the honorable court, my lord, directed to pay. The respondent stated that the submitted before this honorable court that the budget was there and budget because that was expired, Lordship. This honorable court, my lord, again to pay that amount, Lordship. Now, this is order party portion as at page 39, Lordship. Then, my lord, although the amount was paid, Lordship, the my lord, entire, my lord, grievances was not, my lord, redressed with the petitioner's, Lordship. Then another petition, kindly see 5/7/2001 at page 42. This is very important, Lordship. Annexure 12.
40?
Page 42. WPC 5/7/2016, Lordship.
Yes.
My lord, from my second para, my lord, I am reading, Lordship. The matter pertains to grant of area of pay which according to the petitioner has been denied, though he had been attending his duty. Without advert in the detailed facts of the case, it would be sufficient to say that the petitioner, who is an Assamese language teacher in Pratapgarh Public High School, was on leave as he was suffering from tuberculosis, TB, for certain period, that is 1/7/2010 to 30/9/2010, 1/10/2010 to 30/11/2010, and he resumed his duty on 1/12/2011 after his recovery on treatment. Next paragraph. In this regard, it has been submitted by the state authorities that as far as the leave period from 1/7/2010 to 30/11/2010, 1/4/2011 to 30/11/2011 are concerned, the said leave have already been regularized by the authority, and as such the petitioner would entitled to area of salary for the said period. However, it has been stated on behalf of the state respondents that though the petitioner claims to have resumed his duty on 1/12/2011, he was allowed to sign his attendance register only on 27/8/2012, and as such the authorities had declined to grant salary for the period from 1/12/2011 to 27/8/2012. As mentioned in the order dated 10/7/2015 issued by the Director of Secondary Education Assam, a copy of which has been annexed as Annexure 13 of the additional affidavit filed by the petitioner. Accordingly, the only issue to be decided by this court as to whether the respondent authorities should be directed to grant the paid allowances for the period of 1/12/2011 to 27/8/2012, during which period the petitioner claims to have attended his duty. As regards this contention, since there is a dispute as to whether the petitioner had actually rendered service for the said period or not, it will be more appropriate if the authorities make an inquiry as to whether the petitioner had really rendered service as claimed by him, or the headmistress of his school had declined the petitioner to put his signature in the attendance register as claimed by the petitioner, and upon such inquiry and verification, the appropriate order may be passed. the petitioner had been allowed to resume his service by order dated 24/8/2013. As the petitioner is claiming for his arrear of pay, and since the claims to have rendered his service from 1/12/2011 to 27/8/2012, except for the leave period, which had already been regularized by the authorities as mentioned above. If it is ultimately found that the petitioner had attended his duty from 1/12/2011 onwards, but was refused by the headmistress of the school to sign the attendance register for the aforesaid period, the aforesaid period shall be treated to be on duty. Accordingly, the payment of the arrear will be dependent on the inquiry that may be undertaken as directed above. If upon inquiry it is found that the petitioner had attended his school as claimed by him to resume his duty on 1/12/2011, and the headmistress had disallowed him to sign to attendance register, in that event the petitioner cannot be blamed for not attending the school, and in which event the aforesaid period of 1/12/2011 till 27/8/2012 shall be treated to be on duty for the purpose of pensionary benefits as well, apart being entitled to the salary. Another grievance, that is, my lord, as required, my lord.
Now, this period has been treated to be what?
My lord, treated salary is not paid.
It's leave without pay.
Yes, my lord, that is that.
Now, what is the leave available in your account?
My lord, leave about, my lord, as for my lord tuberculosis, this is special leave, lordship. For that period, my lord, I am entitled to be, my lord, the salary, lordship. The honorable court, my lord, earned leave, lordship. Other part is earned leave, lordship. Earned leave cannot be adjusted to any other leave, lordship.
No.
134 days.
Do you have that earned leave at your disposal? That many number of days, 272 days?
134 days, lordship.
How?
I have stated, lordship, in paragraph 16, lordship. Calculation is also there, lordship. Now, another part, lordship, kindly be seen at next paragraph, lordship. Another grievance, lordship. My lord, in this paragraph 45, lordship. Another grievance raised by the petitioner is that although the authorities had sanctioned specially for TB on medical certificate, it has been also directed that the sanction of leave will be after exhausting his earned leave. Learned counsel for the petitioner submits that as provided under Rule 3 of the rules regarding medical examination and treatment of tuberculosis, government servants in the TB sanatorium and clinic, Shillong, and other recognized institutions in Assam, a permanent government servant shall be entitled to leave on average pay of for 18 months by the installments of 4 months on the recommendation of the medical officer concerned, in addition to all other leaves due to him as provided in revised leave rules 1934. In other words, the aforesaid special leave on medical certificate is an entitlement which cannot be adjusted against any other leave of the petitioner. The court, having gone for the aforesaid leave rules, is also of the view that since the authorities have made a special provision for granting of leave on account of illness from tuberculosis on medical certificate, the said leave granted to the petitioner on medical ground cannot be adjusted against any other leave. In fact, the said leave will be addition to the other leave entitled to the government employee. Accordingly, it is also directed that the aforesaid period of leave sanctioned by the authorities as mentioned in the order dated 10/7/2015 shall not be adjusted against any other leave from 1/7/2010 to 30/11/2011. Yes, my lord. This is the, my lord. It is answered by this honorable court, my lord. The honorable court in this order, my lord, this is answered, lordship. And direction was there, lordship. Now the import order, my lord, what I have, my lord, prayed for, my lord, modification, lordship. This is not clear. This is not, my lord, clearly stated. Only, my lord, the period, my lord, regularized, my lord, without pay, lordship. That is now, my lord, kindly see paragraph 16 of the report. I have given calculation, lordship. I'm sorry, Lordship, that's, my lord, from page 11, Lordship, paragraph 12, Lordship. Paragraph of that after withdrawal and giving undertaking on compulsion by the impound order dated 12/2/2021, the
What is
IS
the
has
leave available in your credit? Tell us that. What is the leave as per
leave,
your-
Michael, page 30, paragraph 13, Lord's paragraph.
What is the
Leave.
number of days available to you?
My lord, this is 300, my lord. The honorable court, my lord, has, my lord, held in judgments. And in the meantime, my lord, the honorable court, my lord, also directed in many cases, lordship, to pay, my lord, 300 days, my lord, earned leave, lordship. That cannot be adjusted with any other leave, lordship. And the special leave, my lord, on medical ground, my lord, tuberculosis, lordship. It is also no, it cannot be, it can also not be, my lord, adjusted with any other leave, lordship. Now this is adjusted, my lord, on the other than, and my
No,
lord,
you have utilized this leave at para 13.
paragraph 13 of this petition, lordship.
Yes. You have given a calculation.
Yes, sir, this is the calculation,
So
lordship.
you have utilized this leave.
Not utilized, lordship.
Then
This period, my lord, this is unlit, my lord, my lord. This period not, my lord, paid, lordship. And my lord, the special leave, my lord, for that period, lordship, that is adjusted with this leave, unleave, lordship. This is my grievance,
no.
lordship. This cannot be, lordship.
No, your, you come to page number. Page number 35.
Page 35, lordship.
So this 35,
Yes.
these three periods, 1, 2, and 3.
8 months, lord. This
3
is
months,
medical,
3 months, 2 months, 8 months.
this is medical
is-
report,
This
medical
is
ground, lord.
treated to be medical.
It cannot be adjusted with unleave, lord.
Correct. So your grievance is from 1/12/2011 till 26/8/2012.
Lordship.
That is the period
This is, yes, this period, lordship, this is very,
treated as earned leave.
no, lordship.
Then
This period, lordship, I went to the school, lordship. The headmistress, my lord, did not allow me to join my.
that's right. Now, how do you disprove it?
My lord,
On what basis do you say that the administrator did not allow you to join?
my lord, this is, I have stated in the petition, in the order, lordship,
Did you file any
no
representation?
inquiry is done, lordship.
Did you file any representation before the authorities where that you are not allowed to join?
Yes, my lord, that is why, my lord, in the order, this honorable court has specifically stated, lordship,
Ah.
and directed the authority to make an inquiry, lordship, whether, my lord, this apartment is correct or not, my lord, they directed to inquiry, lordship. Nothing was done, lordship, only by this, my lord, last order, my lord, the period was, my lord, this period was, my lord, regularized, lordship, without pay, lordship. The honorable court has, my lord, specifically stated, my lord, if it is found, my lord, the headmaster did not allow me to join, my lord, then I am entitled to pay. My lord, if it is not found, lordship, no inquiry is done, lordship.
Correct.
So this is, my lord,
So my instruction, my lord, on his application on 31/2021, he prayed for granting extraordinary leave under medical ground, my lord, without pay from 1/12/2011 to 28/8/2012. On the basis of his application, this leave was granted, my lord. It was his,
Where is his application?
I have received the instruction, my lord.
No. If his earned leave is available,
Yes, my lord.
he's entitled to take that period for earned leave if he
Yes, my
wants.
lord.
Now, in the calculation which he is referred to,
It is his calculation, my lord.
whatever, in page 13, he still has 134 days.
Yes.
Which will cover this, at least
272, half
of it.
Yes, my lord.
So it should have been covered.
Yes, my lord. That instruction I will apply, my lord, whether there was any earned leave available. But my instruction, I have received the application filed by him seeking extraordinary leave without pay.
You have filed an application. Department says you filed an application because of which this order was passed.
my lord, this is, lordship. Well, no inquiry was done, my lord. This is against the order of the honorable High Court, lordship. My lord, the,
I'll
Get
bring,
that application, place it before the court.
I'll bring it on record by way of an affidavit, my lord.
my lord, if any inquiry report, my lord, that may be brought on the
Counsel,
record of this honorable court, lordship.
standing counsel for the investigation shall bring on record, shall file an affidavit explaining. Let's go with any arguments. Currently, is available to the credit of the record and as to why the impugned order dated 12/2021 was passed, granting extraordinary leave without pay on medical ground for 70 days for the period 1/12/2011 to 28/8/2012. The respondent will also plead to the court, will also apprise the court as to whether the inquiry was conducted, find out as to whether the petitioner's claim that he was not permitted to join school by the school principal is correct statement. So let the matter be listed again after.
Obligor.
Obligor.
Yes.
May I please, your Lordship? Lordship, on the last occasion, Lordship was directed us to take instruction regarding second ACP. Lordship, some process has been initiated, Lordship, but as per we have written the letter, Lordship, but instruction is awaited, Lord.
How much time do you require?
Within 2 weeks, Lordship.
2 weeks?
Last answer.
Sir, N. Sharma.
N. K. Sharma, Lord.
K. Sharma, that is
On behalf of Mr. H. K. Das.
bring forward. K. Sharma. This.
Date may be fixed. 2 weeks.
Again on 31st.
Obligor.
Lordship. Deeply obliged.
May I please, your Lordship? Lordship, the respondents were directed by this honorable court to apprise this honorable court why the amount has not been released to me as per the order dated 26/5/2023. If my lord sees there's order at paragraph number 6. What has happened, my lord, in this case is the petitioner was put under suspension, my lord, for a certain period. Thereafter, he was reinstated, and the period of suspension, my lord, was treated as on duty. And that period, my lord, the salary has not been paid, my lord. And this is the grievance of the petitioner before this honorable court. And numerous representations and applications were filed, my lord. Thereafter also, it has not been paid. Even, my lord, the respondent number 3 at page 24 of the, my lord, petition, my lord. At page 24, my lord.
My lord, here I have received instruction, my lord. As per instruction, my lord, proposal was submitted to the government, but pension was not received during the financial year of 2023 and 24. Now, director has seek for resubmission of area proposal. That instruction was.
how much time is required? Getting the non-royal certificate?
My. But I
Get it within a week
Right.
and forward it. Your proposal could not be forwarded to the period left. Now it has to be reprocessed and then again. Hard time to publish. Sir, take that. By the director. Requesting for fresh, non-royal. After time. Right, third, or payment to various entities. Earlier, right, right, expiry. Not work also right. Five, 7, 5. That view of the matter. The third is 31st.
Obliged.
31st. No, let us have it on third of June.
Obliged.
By which dates is expected that the formalities necessary for forwarding the proposal for respect of various entities is completed by the department. Based on third.
Obliged. My lord, in this case, my lord, after the death of the husband, my lord, was a teacher, my lord, husband of petitioner, my lord, she prayed for my lord, family pension, my lord. There, my lord, instruction sought for, well, accordingly, I received one copy of a letter, my lord, 6/7/23. Letter was issued by the inspector of the school, my lord, Karbi Anglong, addressed to the director of pension, my lord. In that letter, it is saying, my lord, submission of pension case in respect of petitioner, my lord.
Particular form of calculation I don't like.
Yeah, then
Thereafter, my lord,
Petitioner was asked to, my lord, submit the application for relaxation under Rule 205 and 206, my lord. Petitioner has not yet submitted that application in that particular format. Petitioner submitted in a simple application, my lord. It is not under that particular format.
where have you indicated the format?
That
Any affidavit type?
affidavit we have not filed, my lord, but the government communicated it, director of pension, to let's look into that in, sir. Zero five and 206.
Submitted by the inspector.
My lord, that particular, my lord, for relaxation petitioner, next page, my lord, what should we look into the, what is the application filed by the petitioner? The simple application, there is no ground, my lord, why the relaxation is required to be made, and that particular format, the petitioner is required to sign it, my lord. So the inspector wrote to the petitioner, my lord, to submit the form in that particular format, my lord. And whatever the paper petitioner submitted, we have already forwarded it, my lord.
You apprise
Petitioner, my lord.
about the format, where is the form?
My lord, the,
Format is not available here.
my lord, the petitioner is required to submit it, my lord.
That's why you give the format, what format you want. Yes.
My lord, that is the public and pension grievances department, my lord, not by us, my lord. Rule 205 and 206, my lord. We wrote to the petitioner on 16/3/2024, my lord.
No retrospective effect, that means that it current, they will be able to 206 it is there.
There is no particular format. No particular format indication.
We have already forwarded his application, my lord. On 16/12/2023, we have already forwarded that particular application.
Then?
That is a letter, my lord, first letter, my lord. We have already forwarded it to the, then my lord, government will respond it to.
My lord,
Yes.
instruction is that, my lord, it was not submitted through, my lord, I will just read the instruction, my lord. The pension proposal of Miss Srimati so and so has been returned to the Inspector of School of Karbi Anglong by department letter such and such for submission of the same through proper channel. And further, my lord, that relaxation, whether he is seeking relaxation under 205 and 206, that has to be, my lord, in a prescribed format.
Where is the format? Under what provision is the format?
Under what?
Apply the format, whatever format is there, you commit it.
Yes, my lord.
What is the format?
My lord, if the council will seek the thing or the petitioner
We
will
are
go to
asking
department, my lord.
You as the council for the department, you are for the pension department.
My lord.
You are insisting on.
That is the, then, my lord, I will bring in the format on an affidavit.
Why do you have to bring it? You just throw us from the rules. Where is the format? What format is this? In the rules prescribe a format.
Yes, my lord, that is what,
We pass it in our order that it is to be submitted in this format.
that is what my lord instruction says, my lord.
What is the format?
Format, my lord, I'll have to seek that format, my lord, from the department, my lord. The problem is that, my lord, the council who handles this matter, my lord, today he is indisposed, my lord, Mr. Saikia. So I'm just appearing on his behalf. That's the problem, my lord. So what can I do is, my lord, I will get the format, my lord, from the department.
You place it before the court, the format by Monday. You're appearing for someone?
On the number 4. Miss D. Mohanta on behalf of Mr. Rishi.
Hearing for respondent of the court.
4. We have Mr. Risha.
Doesn't it submit that the section of the has been returned back to which department?
To my lord, school inspector, my lord, Karbi Anglong.
School inspector,
Karbi Anglong.
subject for format.
Proper format.
For claiming exemptions under
205 and 206.
pension.
My lord.
Reader and counsel. Format describe. Which the submit. The acceptance is required. The matter be listed on page 20. 0.
My lord, can it be on 22, my lord?
22.
22, my lord.
22. Yeah.
My lord, the petitioner while serving as the circle officer at Dolgao in the district of Marigao was arrested, my lord. And my lord, therefore, under Rule 6(2), he was placed under suspension, deemed suspension, my lord. Thereafter, my lord, the date of arrest is 10/11/2022. Then, my lord, he was placed under suspension by order dated 12/11/2022. And 14/11/2022, he was granted bail. And the authorities failed to review the suspension order within the stipulated period of 90 days. However, subsequently on 18/2/2023, they reviewed, my lord. And in the meantime, my lord, the criminal proceeding is also going on and a departmental proceeding has also been initiated. That is also going on. But my lord, the petitioner has not been reinstated. He is still under suspension.
There is no review.
There is a review, but the first review was done beyond the period of 90 days. That is our contention. And subsequently, when the last review was done, the review order only says, as per the earlier review order, the situation obtaining then is still obtaining, so his suspension is continued. And as your lordship knows, as per other Chaudhary, a reason order has to be passed for continuation also, my lord.
Yes.
Yes, Lordship.
What is this?
Last review order.
And lordship, before it, there is a lordship
Last
order. Lagan Baswar, recent order by your lordship only. The suspension.
Why are you not reviewing in spite of there the office memorandum being there?
Yes.
Lordship, it is,
Why this review is not being carried out?
Lordship, it is carried out time to time, Lordship. This is last review order,
He
Lordship.
says it was not carried out.
Every 90 days it has to be carried out, man. Petitioner was suspended in the year 2022. We are in 2024, my lord.
And what is the status of the disciplinary?
Lordship, Lordship, department proceeding is going on. Next date of hearing is fixed on 6th of June. Probably this should be the last date, Lordship. Last day, Lordship. Now, may I please, Lordship, if matter is fixed after 4 weeks, then matter maybe this matter may become fast, Lordship. Last day.
They already know the outcome of the DPA, it seems, my lord.
Otherwise, Lordship, we have done it on time, Lordship.
Where is the suspension?
My lord, the lordship will kindly take up the writ petition. Page 34 is the suspension order.
Thirty-four.
34, and except for my lord.
Yeah. It was passed on 12/11.
12/11/2022.
Then first review.
The first review, next page, my lord. 18/2/2023. And the reason given is that the criminal case is pending and investigation is going on. That is the reason for extension of the suspension, my lord. Had it been a case that there is an apprehension that I might tamper with the evidence, I might tamper with the witnesses, I could have understood. preparation of draft charge sheet.
You're getting your subsistence
Yes,
allowance.
I'm getting. No, my lord, Lordship will aware, my lord, the continuous prolonged suspension takes the color of a punishment, my lord.
When were you placed under suspension?
My lord, the pre-page, my lord, 22/11, my lord, 12/11/2022.
And when were the department?
Lordship, show cause notice was issued, Lordship, 17/3/2023, Lordship. Search it, yes. Memorandum of search was. Otherwise, Lordship, everything has been done on time, Lordship. The petitioner was suspended on 12/11/2022.
Where is the show cause?
My lord, we have filed an additional affidavit
Memorandum of search,
in their affidavit in opposition there.
page 57, Lordship. Running page, Lordship.
57.
57. Starts at 54.
Lordship.
Starts at 54.
Thanks.
Yes. Running page 54. And the part of their affidavit in opposition.
What was the finding here in this judgment that you relied on?
My lord, in this judgment, this honorable court was adjudicating the issue whether in respect of a suspension, deemed suspension issued under 6(2), my lord, whether the principles of other Chaudhary will apply or not, and your lordship has upheld that, my lord, and since in this case there was no review, and your lordship has interfered with the suspension order and directed the petitioner to be reinstated in service. At page 12, my lord, page 12 of the judgment, the line starting from 1, 2, 3, fifth line starting from the top, however, as noted above. As your lordship got it at page 12. The lordship was pleased to discuss all the relevant judgment holding the field, including other Chaudhary and our honorable division bench judgment. However, as noted above, no such exercise appears to have been undertaken in this case. Under such circumstances, this court has to unequivocally come to a conclusion that the continuation of the suspension of the petitioner with effect from the issuing suspension order dated 27/3/2023, having not been reviewed, and which position the learned additional senior government advocate Assam has disputed on the basis of instruction received, the impugned order dated 27/3/2023 is required to be set aside and interpreted.
Here is the case where there was no review.
There was no review.
Yes, Lordship. Lagan Baskar, Lordship. Yes, I
There
was
was absolutely no review.
There was absolutely no.
here. Review has been done on time, Lordship. Time to time it is reviewed. Lordship. Next date
No,
of.
there are two lines of judgments here by this court.
Yes, Lordship.
One is that 90 days, 91st day it is illegal. There is other line of judgment where it says this arithmetic precision not to be applied.
Not applied.
My lord, the Honorable Supreme Court in Deepak Mali's case, while interpreting, my lord, the CCA rules, Rule 10, has.
No, there the rules were specific. Within
There is
90 days.
specific, but suspension is suspension, my lord. Whether it's under the
No,
state
the
law.
rules
or
are- No, the rules are specific.
There is
Here
specific.
the rules are not specific.
not specific, my lord. The principles will definitely follow because it's a case of suspension.
So
So that,
where the rules are specific,
my lord,
that is the 90 days.
my lord,
Then from 91st day, it becomes
true, my lord. That is specifically mentioned there in the CCA rule. But in the case of Deepak Malik, though pertaining to, my lord, the CCA rule, the Honorable Supreme Court has said beyond 90 days review.
will require examination whether your suspension has been treated to be like a punishment,
My lord,
while the disciplinary proceeding is still going on.
my lord,
They deliberately kept on.
my lord. And my lord will also consider the Honorable Supreme Court in Azhar has categorically stated, even if charge memo or a review has been done, a recent order has to be passed, my lord. Merely stating that draft files has been prepared, that cannot be a reason in my humble submission, my lord, for keeping the petition under suspension.
What is the status of the inquiry? You said?
Lordship,
Department.
department proceeding is going on, Lordship. Next date of, that is fixed on 6th of June for proceeding, witness, examination of witness, Lordship. Last test,
6th
Lordship.
of
6th of June, Lordship. Last test, Lordship. Several witnesses were, Lordship, examined, Lordship. The allegations are very serious, Lordship, in this case, Lordship. 2 or 3 persons have already been terminated from service, Lordship. Others are also, Lordship, suspended.
require some examination.
Lordship.
The suspension is not. Matters will have to be examined on a case. Facts and circumstances.
True.
Whether the manner in which it is kept under suspension amounts to
Punishment.
whether there is a malafide exercise.
It's a short date and we hear the matter.
Both of
6th of June, Lordship. After 6th June, Lordship.
Huh?
After 6th of June.
after 6.
While learned friend was very categorical in saying that after 6th of June, this will become infraction.
Maybe
It's predetermined. My lord.
after 6th of June, Lordship. Because
11.
11th.
11 on 11.
Lordship. Lordship.
Alternate counsel to the district. Submitted by the respondent counsel that the inquiry proceedings are being carried on. And the next date fixed is 6th of June for examination. of witness. The counsel for the petitioner on the other hand submits that the suspension, besides being illegal, the same is continued in total contravention with the proposed law rules as well as the law laid out by the ethics court, as well as the ethics court. Matter will require some hearing. Matter will be listed on 11th of June.
11th.
Is agreed to by both.
Lordship.
Deeply.
May I please keep over here?
Yes.
Here, your lordship, the petitioner has retired from service on as a deputy registrar, your lordship. On 31/12/2021, your lordship. If your lordship comes to page 14 of my petition, your lordship, you'll find.
So any affidavit filed?
Lordship, I have sent it for vetting, but it is not returned back. So lordship, in the line of our high court judgment, last page, lordship may dispose of the matter.
Last page?
Page 27. Page 27 it starts, lordship. I have sent it for vetting, lordship, and reminder also sent, lordship, but it was not.
So you agree that this judgment will
Lordship, that can be lost.
Third turn account. Turn to page 20.
Only lordship increment date, I mean,
1/1/2020. Page 14, your lordship.
first
Date
reading.
of increment.
Page 14, your lordship. He will draw next annual increment 1/1/2020.
1/1/2020, from that it will be 1 year counted lordship.
1/1.
2020 lordship. In page 14, annex B lordship.
Page 14.
Lordship.
Well, here I am supposed to file my affidavit, bring on record the cabinet memorandum. My lord. I have received the cabinet memorandum. My lord. I need 2 days time. My lord.
Mr. N.K. Khatoniar, understanding counsel, subjects that he has is in receipt of the cabinet memorandum, which we like for raise for a week's time. So, prayer made for a week by Mr. S. Mani. Still after 1 week.
Yes, my lord.
'27.
Yes, my lord.
27.
Obliged, lordship.
Oblige, my lord.
Yes.
Lordship, in terms of the last order, Mr. B. Sharma is required to produce before your lordships the creation of the supernumerary post,
Mr. Lee Sharma.
standing council AG.
Where is the standing council AG? Standing council AG.
Nayan. Nayan. अरे बस हमको दिखाएं, पीछे.
We take it up at 2. At 2 p.m.
Lordships, just a little while, to have something fixed before the.
All right.
Court number 2.
All right. Is he available?
Lordship, I'm told that he's not available. One of his juniors was.
I would like to place something. We had passed an order specifying the retirement date of the husband of the petition. It's a recent one. In between, there was a mistake regarding the order, so the accountant general asked us to rectify the error. Now, this is the latest order, which will enable the office of the accountant general to create a head of account for the petitioner's husband.
That's what we wanted to know. Where is the accountant?
Lordship, I'm told he's coming. I will pass it over the time being. Deeply aware.
Accountant general, the teacher.
He's here, your lordship.
Yes.
Apologize, lordship. It's in another book. Lordship.
Have you received any instruction?
Yes, lordship. We have received the payslip. We have forwarded the payslip, lordship. Can I have it? Yes, yes, thank you. Fine. Well, we have a PhD now.
Payslip has been issued.
Lordship, payslip has been issued, which means now the department, PhD department is required to do the necessary, this thing.
Mr. Kotaku.
Lordship, I'll take note of this, but will.
Third level. Okay.
To me, the copy will go, yeah.
Copy can be cleared.
D. Mohanto on behalf of Ms.
You are there, Mr. Or
For 6 and 8.
Yeah, 3, 4.
in terms of
Very,
the
very
last
okay. Please
and
go
submitted in- in- that- that both are appropriate from one super different inputs, bank of assistant engineer, assistant executive. each of the people that the counted that basically on 1,554 people with apartment release the salary the board have permitted each time affected by the apartment and they were the salary of the bit of the list up
When a timeline takes a date that we obliged.
31st March, May
31st.
31st May. Take a copy of the practice case for the
Deeply obliged, much obliged.
yes, Mr. Singh.
Well, look, here in this case, I have completed 16 years of service, madam. But sometimes, my lord, due to mental disorder, I discontinued in service, but I was not suspended from service. So, my lord, during service, my lord, I retired. So, my lord, I am entitled to pension, etc. my service benefit. That is my prayer. So, my lord, respondent file a short affidavit claiming that we'll file a detailed affidavit, but till date that detailed affidavit has not come. We have made reply to the short affidavit, madam.
Respondents,
No,
who is
I-
filing? You are appearing for PNRD.
No, I'm for accountant general.
Who's for the PNRD?
Respondent number 2. Let respondent number 2 file the affidavit. madam. Huh? Affidavit. From page 51 is our reply, madam.
We direct the commissioner to examine and in case there is no departmental proceeding against the writ petitioner, his salary is reported.
But I'm not claiming salary, madam. Salary has been paid. Only pension and service benefits, madam.
Pension.
Yes. Only
Who's for the PNRD? Standing council PNRD. Is informed, we'll take it up at 2 PM. please.
Madam.
At 2 PM.
Yes, sir.
We don't want to pass an order in their absence.
Madam.
Yes, but
2
here,
PM,
obligation will come.
propriety.
Obligation. Make please, Lord, sir.
This matter may be had by, to be had by division bench, my lord. One of the prayer is to strike down, my lord, subsection 3 of section 43 GST Act, my lord. Prayer number 1, my lord.
Prayer number 1.
1, my lord. Page 53, my lord.
Page
53.
The writ petition has been filed by the petitioner with the following prayer. Expected prayer, page 53. Right. Since prayer 1 pertains to striking down of declaration of clause 4 of subsection 3 of section 140 the CPSC Act, and for striking down the same, registry to place the matter before the division bench. Is recording.
Deeply bad.
KLF. Pass for the day.
Item 42.
42.
42, that is the matter related to the pension of the husband of the petitioner, lordship. Dear lordship, the last order, can you see the last order, lordship? 5/4/2024.
Yes, Mr. Hazarika had appeared last. 42, yes. ARTP and PG.
My lord, I have received an instruction, my lord, that we have processed the file, we have sent it to my lord. We means, my lord, the Home and Political Department. Home, my lord.
No, that is reflected in the order.
My lord.
Now move the ARTP and PG. So have you sent the proposal?
My lord, proposal will be sent now. It went to Finance Department. Finance has sent it back, my lord, with some queries, my lord. That is the latest status, my lord.
Queries have been met.
My lord, that is not reflected in the instruction, my lord. Obviously, my lord, when it has come, we will send it back. I have to take the latest status, my lord. That is on 3rd May, my lord, 24. That is the status. 3rd May, my lord. So now we are in. I will seek, my lord, as to what steps have been taken, my lord. Who is saying this? As per the rules of finance department, has to do with the office seeking certain information from either.
Ordered to be
I was moved to RTP and
Lordship.
Your lordship, it is under the process, your lordship, for the release of areas salary.
What is under process?
For the release of the aerial salary, your lordship.
How long will you take?
Another 2-3 weeks, your lordship.
2-3 weeks. 4 weeks. MS KTV. Here's for the Standing Council for the
Secondary.
Secondary Education. Submits that matter is under process, brings forward further. 4 weeks time,
When the date may be given.
let the matter be still after 4. It's on 7 of June.
I'll apply.
But the petitioner, who is a grade 4 employee, was appointed by the then Deputy Commissioner of Sunitpur after the death of his father. My lord, I take your lordship, the Annexure 1 is the appointment letter issued by the Deputy Commissioner, my lord. That is in page 17, Annexure 1, your lordship will get.
17.
17. In the interest of the public service, the Kamal Kotoki, son of Novo Kotoki of Kotoki Suburi, post of Vasaria, Punitpur, is hereby appointed on a compulsionary ground at fixed pay of 900. That is on
6/8.
yes, August 97. So next day he joined, my lord, and since then he is working, my lord. But my lord, his service was not regularized till today.
He's still working.
Is still working, not regularized. And my lord, in the meantime, my lord, I take your lordship one judgment over High Court earlier, my lord, it was disposed of. Page 38, kindly come, my lord, page 38.
So there was a direction to
Yes, to regularize, to consider his case, my lord.
But that was, you did not file any contempt after that.
No, my lord, our salad was stopped. Then, my lord, another judgment by a High Court, 47, kindly, which is almost complete judgment was given. Even then, nothing was done, my lord. They are paying me salary now. Salary was stopped.
Then?
Then, my lord, now I'm getting salary, fixed salary, I'm getting about 26,000.
File contempt, why have you not filed a contempt?
My lord, we filed contempt when salary was stopped. But then honorable court has.
No, your prayer before this court is what? For regularization.
Yes.
This court has
Now,
already.
now their stand is that.
No, Mr. Biswas,
Yes,
come
sir.
to page number 49. 49,
Page 49.
subpara.
Yes, sir. Coming to the facts, my lord, may I read?
Yes.
A fact that since the petitioner has been rendering continuous service in a vacant post of peon since 97 and is also receiving regular pay scale on the basis of the approved granted by the Finance Department of the Government of Assam. As the court is of the opinion that by virtue of a long and continuous service, petitioner can be treated as a permanent employee. As such, there cannot be any question of regularization of service of the petitioner in the grade 4 post held by him based on further order from the government. In other words, the petitioner for all the intents and purpose is discharging his duties as a regular employee in a vacant and sanctioned post under the establishment of Response Number 4. To the extent no further direction of the regulation of his service is called for. If the petitioner is aggrieved by the pay scale given to him, in that event, it would open for the approach to the court agitating his grievance. Now I have come that I am not getting any regular pay scale.
What is the response?
Responding, they said that
Actually, Achuranjan Das was not followed. Deputy Commissioner cannot directly appoint. Now, Achuranjan Das case came after 97, my lord. His appointment was 97.
Who's for the respondent here?
I am preparing, my lord.
Yes, what do you say?
My lord, to start with, my lord, regarding regularization, my lord, after my lord Upendas, para 22, retable 45 of 2014, my lord. This,
When was it?
this
When was
court is, this court has already held, my lord, that regularization, my lord,
When was the judgment rendered?
2017, my lord,
When Dutch?
Upendas, my lord.
This is for Master Road.
Master worker. Here is an appointment, my lord. He was appointed, my lord, not in a sanction post. You know, affidavit you have stated, my lord.
There is
And that is,
an order of the court.
they should have come for, my lord, now, since, my lord, already this division bench has held.
You read 49.
I have read, my lord. But now, my lord, as of today, my lord, division bench is holding the field, my lord.
Maybe because that is order needs correction, for which you'll have to take steps. If not taken. This
They
order
were filed an
may-
appeal also.
My lord,
Giving them liberty to come before the court for grant of appropriate scale, which is up now. This order
my lord,
is an order passed under Article 26,
my lord,
directing that it regularize.
my lord.
No further order is called for. Regularize. Whether this order would have been passed or was passed without noticing when the judgment or
My
whether
lord.
it cannot be passed. are
Maybe, my lord,
decided.
my lord, maybe that was not placed before the court that he was appointed not in a sanction post.
So whatever it may be,
My lord.
but its process of correction cannot be carried out by this court.
My lord, exactly.
So the court has said
We have to go into a review, my lord,
I
of
don't
that.
know what you have to do.
We have to go into a review. We
Where
have
you
to
apply.
bring in that, my lord. That is there, my lord. But as of today, my lord, Upendas is holding the field.
Upendas is holding the field. We are not disregarding Upendas.
My lord.
So is this order.
My
How
lord,
long this order remain?
my lord, Upendas is always override this order, my lord.
Who will give that finding? You can't give a finding. You are submitting.
My lord, exactly. My lord will hold it, my lord.
I cannot because this is the decision of the court.
My lord,
I may disagree. That's a different issue.
my lord.
But I cannot hold that this court bench order is correct or incorrect or division bench's order is definitely binding. Whether this order should have been passed or not have been passed, that is taken
My lord,
by taking whatever steps is permissible under law.
my lord.
But as on date, this order holds the field. If it holds the field, he is regularized. If he is regularized, the title regular state.
My lord, but we did not pass regularized order, my lord.
You don't. That is what the order says.
He should have come in contempt, my lord. If he would have come in contempt, we would have responded, my lord.
His failure to come in contempt
My lord.
is not going to dilute this order.
But my lord, Upendas is coming in my rescue, my lord.
That is your submission. But this order is very categorical order.
Even Upendas is very categorical, cannot be, my lord.
This order is an order where this order is for the petitioner.
My lord.
This is not a generic order. This
My
order is in response to an application filed with the writ petition. This court under exercise of 220.
My lord.
Powers under 220. It's a very categorical order. It's regular.
My lord.
No further orders are called for. This order was passed on 31/2020. Now more than 1 year, you have not done anything. We can convert this writ petition into contempt.
My lord will respond. If my lord converts, we will respond, my lord. Whatever steps will be taken, we will take steps. My lord will issue notice.
Notice where? You have already filed your affidavit.
No, my lord, in contempt.
But once an order is passed, you are expected to carry it.
My lord, I understand, my lord. That part I understand, my lord. We'll take whatever, I will consult my client, my lord. That I can do, my lord. Let the matter may come after 3 weeks, my lord. In the meantime, my lord, I will take corrective measures, my lord, whatever.
Yes, Mr.
I have got no objection to the submission made by my, only one thing that it will not come. Upendra cannot save him because he is not a master roll worker. He was directly appointed by the deputy commissioner as a, on compassionate ground.
That is his argument.
Moreover, my lord,
My lord will just see the appointment order, my lord. It is temporary in a fixed pay.
yes. But
Compensation
time to
appointment, my
time
lord,
in
is always on.
since 97, you have now come to it,
My lord-
30,000 salary.
But this order has held. I have read and reread this paragraph,
My lord,
page 49.
my lord.
The court's view is very clear that by virtue of his long and continuous service, he is to be treated as a permanent employee.
My lord, here the thing is that with salary, that minimum pay scale, my lord, that was turned down by finance department. We have tried, my lord. It is not that we haven't tried. We have tried to bring him in. But his entry to the thing was, my lord, there was some error apparent while this appointment was made by the, it was not through district.
Therefore, you take steps.
Yes, my lord, I'm taking steps, my lord.
Order.
My lord,
This order is binding on you
my lord,
as well as on this court.
my lord.
You can't ignore an order passed with a specific direction.
My lord.
We'll defer it
My lord.
by 3 weeks.
My lord.
Let us see what happens after. Mr. S.C. Biswas appears for the requisition. Mr. R. Holder, the relation to the governor. Which department is this?
My lord, this is, I'm appearing for DC, my lord.
Appearing for the district commission. The commission of Supreme.
I'm appearing for one.
Mr. A. Puban for respondent 1.
I'm for 2.
Mr. S. Dotto for respondent 2. Mr. R. A. Choliha for respondent number 3. The respondents will take steps to comply with the directions of this court of a coordinate bench passed by the order dated 3001/2023 in WPC 2990/2017. That will be deferred for another 3 weeks, enabling the respondents to comply with the order.
Let it on 31st May, my lord.
31st May.
Yes.
Let us have it in June.
June.
7th of
First week of June, any date, my lord.
7th of June. 7th of June.
Oblige, oblige.
My lord, I'm sorry, I was not there when the matter was called up in the morning. Item number 21 to 24, my lord. These are all income tax matters. These were last heard in 2020 by your lordship. my lord.
We can resume the hearing.
My lord, I need some time to prepare because I have to take instructions and my associates are also not available. They are not here. So at least, and they have to produce the records also, my lord. as per-
Mr. Keal was referring to a judgment of the Supreme Court.
Lordship,
said-
that is on different point, Lord. After going through the record, Lordship, they have challenged notice under 148. So, Lord, on last occasion, Lordship has directed the department to produce records.
To show us your satisfaction.
Yes, that is the.
So you produce the records.
I'll produce
When can you produce it?
Lordship may take such for
4 weeks time may be given.
4 weeks. 4 weeks is like
In between, I will not be here, my lord. I will be-
2017 matter. 2017 matter.
My lord.
So 4 weeks is
Fixed date
because
may
after
be
4
given.
weeks you'll get another 2-3 weeks of additional time. So we should make an endeavor to close these matters.
My lord, at the time of next hearing, we will also
We will file a compilation also.
Let us have it in the second week of June, attempt. Let this matters be listed on 13 June.
Yes.
13 June. And by which time the Standing Council Income Tax Department will produce the relevant records pertaining to the 147,
148 and
148 notices issued to the writ petition. So, Mr. R. Goenka, Learned Counsel, appears on behalf of the writ petition. List these matters on 13th June.
Lord.
Can I plead your lordship? Lordship,
Yes.
I am appearing on behalf of Mr. K. Kaur, lordship. Lordship, he is out of station, lordship. The lordship kindly matter may attend for today, lordship. In case it, lordship, next week.
There are so many standing councils
Lordship,
for the department. You
lordship,
call any other standing council, we wanted to
Lordship-
close this writ petition.
lordship, Mr. S. Doctor also with his. They're going to Delhi. Lordship, they're going to Delhi, lordship.
It is submitted by the, submitted on behalf of the respondents that the standing council for PNRD department are not available in court. The prayer for adjournment is made. Considering the prayers made, matter stands adjourned for 2 weeks. Mr. M. A. Sheikh appears for the writ petitioner, Mr. C. Barua for the respondent number 5. After 2 weeks.
Oh, bless you.
May pay for a date, my.
What is the use of praying for a date when the councils are not present?
For 2 weeks, my lord. A date.
When standing councils are there, 3-4 handful of standing councils, at least one should appear.
Lordship, today is not available, lordship.
I know he's not available.
Lordship,
Are you telling me that all the standing councils are not available?
Lordship, there are 3 councils, lordship, S. Doctor is also not available, lordship. He is also out of station, your lordship.
Where is Mr. Hendick?
He's not there, lordship. Due to some
Let the
his
matter be
health
listed
issue.
again on 7th of June. 7 June?
7th.
Okay.
Oh, bless you.
That, this petitioner was selected and appointed through a SLC, my lord, on compassionate ground. And my lord, after police verification and medical examination, he was appointed at the office of the respondent number 4, Deputy Commissioner Sunitpur. And in the year 2017, my lord. That is 17/7/17. But my lord, he got a salary only for 3 months. But thereafter, my lord, till today, though he's regularly serving in the office, my lord, but his salary has been held up. My lord, all the respondents have filed their response. The stand of the finance is that Deputy Commissioner, who is the respondent number 4, has taken all possible measure, my lord, with a request to the finance department to arrange his regular salary along with the finance, my lord. But the stand of the finance is that at the time of appointment, finance, there was no concurrence was taken up from the finance. As such, though Deputy Commissioner requested for budgetary allotment, but finance has taken the stand that this is not a possible at this time, since Nitumas Jadikarov, while appointed, financial concurrence was not accepted, taken. As such, though Deputy Commissioner requested for the proposal to be ex post facto approval of the filling up the post, but they have declined. Now, as a result, I am in the midst, my lord, without salary, I am serving 2017.
No, no, let it be listed for hearing on uh, on 21st
Of this month.
of this month. Since the pleadings are complete, matter be listed for hearing on 21st. Mr. A. Thor for the Deputy Commissioner, Mr. A. Cholia for the Finance Department. List on 21st.
Wait, is your lordship. My lord, in this matter, I'm praying for 2 weeks more time, my lord, to file our affidavit, my lord.
Lordship, third occasion time is being thought for.
Well, next week, by next week,
Sorry?
we'll file, my
Lordship,
lord.
third occasion time is being thought for filing affidavit.
My lord, by next week, we will file, my lord.
What is this issue?
Lordship, so this matter pertains to the non-refund of excess TDS which was deducted from our account.
Excess?
TDS, Lordship. For the financial years 2011, 12, 12, 13, 13, 14, 14, 15. For 14, 15, Lordship, the TDS was refunded to us on 13/6/22. But with respect of the rest of the financial years, nothing has been done, Lordship, so far.
Yeah, no counter has been filed.
No, Lordship, not yet.
Yes, Mr. Gogoi.
Well, by Monday, I will file the affidavit. I've got the.
I heard the counter parties, Mr. P. Gogoi, Learned Standing Council, Finance, submits that the affidavit is under preparation and will be filed by having Monday, i.e. 20/05/2024. So, in view of the submissions, let the matter be listed on tenth of June, by which date the affidavit be filed and the petitioners are also at liberty to file their reply affidavit if so advised in the meantime.
Lordship.
My lord, this matter will be taken up after some time, my lord. My friend D. Bora is appearing. He's in another court. He's coming, my lord. In 5 minutes, he will come, my lord.
Lordship, this matter, Lordship has heard substantially and the records have also been finished by my lord. So, transfer matter. And
We'll take it up on, so who's appearing?
D. Bora, my lord. My friend, my lord, government counsel, my lord. He's handling the case, my lord. That's why, my lord. He's here, my lord. He has come, my lord.
Yes.
Thank you.
if your lordship recalls,
According to you, you came before the court on the alleging multiple transfers.
lordship, I was
But
transferred to the
records
present
reveal
case in 2022.
that there was only one transfer order within 1 year. Only one transfer.
Lordship, in fact, there are 2 transfer orders. If your lordship will see.
One is already under challenge
One is under challenge.
and the
I was
early-
transferred in the present place on 15th October 22.
Hmm.
And by 14th September 23, then again I have been transferred out. And that says in partial modification of an order that was issued on 17th of July. Therefore, my contention was there has been 3 transfer orders, but now they say that there is no order of 17 July. So if there is no order of 17 July, then what has been modified? Now, because a draft cannot be modified, an order which is issued that can be modified. Their contention is that a draft order was prepared, which was modified. Lordship, that is neither here nor there because a draft is a draft, it's not an order. And the records produced before your lordship would reveal that there was an application from the mother of the private respondent. And based on that, the transfer was made. And there was another allegation that there were some allegations against me. That, Lordship, if there were some allegations against me, that order of transfer is punitive. And in fact, nothing reflects from this order dated 14 September 23. If I may refer to a judgment of the Honorable Supreme Court in Lordship 1986 for SCC 131. I'll just read a paragraph from there.
Where to, what is the, for what proposition?
Even if it is for the purpose to accommodate another person, that transfer order is malus. Now,
So here they say there was a public complaint.
if there is a public complaint, Lordship, that has to be dealt with separately. There cannot be a punitive transfer. That was precisely, Lordship, the ground on which I was earlier transferred also.
Where is the earlier transfer order?
Earlier transfer order, Lordship, is at page 20 and if I may take your Lordship to the affidavit filed in the IA. In the IA, page 31, which relates to my earlier transfer. Annexure 1 to the IA.
Annexure 1.
Annexure 1 to the IA. In my copy, Lordship, it is page 31. Where an affidavit has been filed by Vivash Modi. He is the Director of Social Welfare. I'm sorry, Lordship, the affidavit filed in the writ petition, not in the IA, Lordship. In the writ petition, Lordship.
Yes.
Page 31, Annexure 1. This was the basis of my earlier transfer order of 2022. That is, if there was some allegation against me, there was an allegation against him also. Lordship, at page 32. So on the basis of that, we were transferred. And that transfer order is of 15th October 2022. Hardly a year has gone. I'm again transferred.
You are generating a lot of complaints. So what to do with you?
No, Lordship, if there is a complaint against me, draw DP against me. Take action against me. But
because DPs, drawing up DPs will require a procedure to be followed, to be concluded. So
here Lordship has
they're trying the easy way out.
Here Lordship has seen the records. There is also an application. The last submission made by the council for the state was, there is an application from the mother of the respondent on the basis of which the transfer order was carried out.
But how does it affect your service
No.
tenure?
It does not really, Lordship, fall in that line.
Then, unless
The
you're
state
alleging,
cannot go on transferring me.
unless the scope of judicial review is extremely limited.
Yes.
So unless you satisfy us that the authority transferring you was not authorized, or there are some legal malice which can be inferred at least.
I would refer to Lordship decision.
We'll continue the hearing tomorrow. We'd like to complete the hearing and pass
Yes.
order tomorrow. Prima facie, we're of the view that
No, what has fallen
your
from your
your
Lordship
entire
is,
writ petition is premised on the ground of repeated transfer. Now, this repeated transfer perhaps is not made out because the second order was really not an order, some corrections, etc. was done.
the order, the impugned order, if your Lordship will see, it is in partial modification of what? It is in partial modification of an order which is not in existence.
We'll continue tomorrow. I
Lordship.
shall be listed tomorrow for admission hearing. We are not recording it, but we'll try to dispose it of tomorrow.
Yes, yes, yes.
Lordship, can I take back the instruction?
Why?
Because I only have one that
You give us a photocopy because your government councils are very busy. Sometimes they are not available in court. At least we can proceed with the hearing. So you leave a copy and you can take back the original. Yes? Tomorrow. Yes.
May I plead the Lordship? They have supposed to file the affidavit. Lordship. Instructions are awaited. my
What
lord.
day? Day means?
Secondary education. my lord.
Yes, you are
Instructions
appearing for secondary.
Yes, my lord.
So
So another 3-4 weeks may be granted. my
3 or 4 weeks.
lord. 4 weeks will be.
4
granted.
weeks. Under 4 weeks time is prayed for by the learned counsel for the
Yeah, Lord.
respondent. Learned counsel for the petitioner submits that an interim order is continuing and the same be extended. Accordingly, matter be listed again on 19th of June. Interim order passed earlier will continue till the next day.
May I please, Your Lordship? My lord, this case relates to the suspension, my lord, and without causing, my lord, any within the statutory period, 90 days, my lord. On the last occasion, your lordship was pleased to ask me to go through that judgment, my lord. That I have gone through it, my lord, and Aftapur Rahman. There also, my lord, similar stand was taken as like other, my lord. Hundred.
The counter affidavit is filed?
Yes, my lord. Under affidavit, they file, my lord, but does not disclose when the review was held, my lord. But subsequent page, my lord.
Let us keep it for hearing on 21st.
Tuesday, Thursday, my
21st.
lord.
That will be listed for admission hearing on 21st.
On that day, my lord, endeavor to be made to dispose of.
An endeavor shall be made to dispose of the next date of this.
Lord.
Mr. D.I. Bhargava for the petitioner, Mr. Rai Bhargava for the respondent.
Make clear, Your Lordship. Lordship, the husband of the petitioner for DRS Lordship with effect from 31/12/2002. The Lordship, the pension has been sanctioned in the name of the husband of the petitioner Lordship. Subsequently, the first wife of the husband of the petitioner expired and in the year 2018 Lordship, the marriage was performed with the petitioner Lordship.
Yes, respondent.
Lordship, here instruction is awaited, Lordship. Need Lordship 2 weeks time to get my instruction and final.
Counsel for the petitioner, third learned counsel for the petitioner, Mr. D. Upamanyu, learned standing counsel. Higher education. praised
No,
for-
Lordship, Health and Family Welfare Department
Health and family welfare.
for respondent 1 to 4.
Praised for and is granted 3 weeks further time to complete his instruction, Mr. T. Bhattacharya for accountant general. That will be listed again on after 3 weeks.
Highly obliged.
May please, Lord. Lordship, kindly ordered it at 10/4/24, my lord. Today is the returnable date.
Yes, respondents.
Another related to suspension, my lord.
My lord, we would like to file an affidavit, my lord, in this regard. We have received instructions. My lord, the thing is that she is shying away from joining this DP, my lord. We have soft copy. She refused to. That is the status, my lord.
Bring it on record.
We are bringing on record.
And what about subsistence
51,
allowance?
No. Going to repeat.
What about subsistence allowance?
My lord, she is not a government employee. She is Anganwadi worker.
Huh? Anganwadi?
No, my lord. Anganwadi or not Anganwadi worker, my lord.
Matron comes storekeeper.
Yes.
Storekeeper, metro, sorry, my lord.
Oh.
That obviously, my lord, that the subsistence allowance will be, my lord.
That has been paid, my lord.
That has been paid.
Yeah, my lord.
That will be paid, my lord.
You have received it.
Yes, substitute.
Heard
If so
Mr.
far
Rajendran
instruction is
Bhatt
concerned,
is
which one I
Commissioner,
refuse, my lord, that was.
Are told and it's. the government
He refused to
application
remove
with
the
this
permit.
Submitted by
Directly to government.
the government.
Sir,
council
so
that
much reply to record of gratitude.
affidavits
Need to reply more.
is under preparation likely and is likely to be
reply.
filed within a
So
short
notice.
days. He prays for
No,
3 weeks for the time.
no.
Prayer made is not objected to by the council to the petitioner. It's a matter after 3 weeks, enabling the respondents to file their counter affidavit. Yes.
Let them file it. Personally, fix it.
Let him file an affidavit.
Item 52.
Yes. You said.
Here one of the impugn transfer order has been cancelled. And my lord, a first transfer order has been issued, transferring both the husband and wife at the same place of posting, my lord. In fact, the choice place of posting. No, this is the order, my lord.
Where is the new order?
No, this is the new order.
No, in your affidavit.
Affidavit was filed at 3 o'clock. The order came out later to that one.
So what prompted you to file the affidavit at 3 o'clock when the order,
No, but my lord, I was not
have
aware
you
of
made a
that.
statement here?
No, because we are not aware of this one. Subsequently, it was passed.
Yes.
Mr. Mazumdar is on legs.
You ask him to come.
Yeah.
We'll keep it aside for the time being. Before the court rises.
My prayer for withdrawal, Your Lordship.
It is submitted by Mr.
A.A.R. Karim.
A.A.R. Karim. That the petitioner does not wish to press the bail petition any further. He craves leave of the court to withdraw bail petition.
I am appearing as an amicus curiae.
Mr. Ujjal Chaudhary has been, who's appointed as an amicus, has also entered appearance. And Learned APP also appears.
B. Sharma.
B. Sharma. B. Sharma.
B. Sharma.
What, you got scared of the amicus?
Already, Lordship, he is already on bail, actually.
He's already on bail.
Yes.
I have checked the record.
See, therefore he got scared. Under such circumstances, it is submitted by the learned amicus that the writ petitioner is already on bail. Considering the said submission, which is not disputed by the counsel for the petitioner, bail petition stands dismissed. Not pressed. Interim orders, it stands vacated. The amicus be given the emolument as for the procedure for his assistance and service in the court in the matter.
Reported record.
Yes.
May it please your lordship. Lordship, in this case, petitioner after obtaining interim bail appeared before the learned court below and submitted bail bond also lordship, and regularly he is appearing, and on last occasion your lordship has status report also.
Status report is called.
Status report, my lord, is on record, my lord. As per status report, my lord, the last date, my lord, on 15/9, my lord, it is fixed for appearance. It is up to, my lord, 15/9/23. Thereafter, maybe it is proceed, my lord. But there is.
Well, our submission is that earlier your lordship rejected it, this bail. There is a double murder from our side. We have lost two of our own brother.
Appear করা নাই তো লেখো appear করা নাই হিসাব appearance হবে না Sí. Estoy con esto. Cancel no.
Report is not received here, I think. No, it is not received. As per the earlier order.
Yes. My lord, that is up to 15/9/23. That is not latest.
Where have you received it?
My lord, I have checked it, my lord. And in the order sheet, my lord, I have
Order sheet.
order sheet, my lord. Export order. No.
It's not here, it's not here. Only the communication is here.
My lord.
In terms of the earlier order passed and the requisition sent by the registry, up-to-date case report has not been received as yet. The registry to requisition the up-to-date case report, status report.
Status report.
By, with illegible scanned copies and be placed before the court. Matter be listed again on 14th June.
My lord, 14 June.
14th June.
My lord, interim order.
Interim order passed earlier will continue. The next week. Oh, yes, you are supposed to produce records and all.
Yes,
What is the point in?
my
pursuing this?
records, my record.
Ah.
We have some records. My records say they, all the 7 private respondents have accepted the appointments offered to them in the year 2018, giving up past claims, my lord.
On what basis are you saying this? But this is your appeal,
Well, it is my writ petition.
by
At that
your
point-
writ petition.
At that point of time, they had not accepted the appointment, so we had not offered them the appointment. But in 2018, 11th of April 2018, after the screening committee, they were offered the appointments.
So what do you say, Mr. Counsel?
Lordship,
That
in
position-
that order, there is no such reflected that we have
I don't know.
accepted
What,
to pass plain.
what instructions, what is the basis of these instructions? You have the appointment orders.
My lord, the appointment.
Regularization order.
The appointment orders are there, my lord.
You show it to him.
It's a regularization order.
You show it to your counterpart.
Lordship,
They had given it.
I have given in my additional rejoinder, Lordship.
Hmm.
Rejoinder affidavit at page 21. Page 31. Serial number 14, 16, 17, 18, 19, and 20 are the respondent number, Lordship,
5, 1, 2,
1, 2, 3, 5, 6, and 7. And regarding the respondent number 4, Lordship will find it page 34. Respondent number 4 regularized in the year 2021.
34.
Page 34. The type copy.
Order dated 30th of January.
Yes, Lordship, 2021.
Hmm. Then
These two orders.
other
And
5 orders are not here.
And similarly situated persons, Lordship, they have already sanctioned and given the arrear salary amounts. That also have annexed, Lordship. That Lordship will find at page.
That part of
Your
the,
instructions are not accurate.
that information is not coming up, my lord. Because on this writ petition also, there is an instruction to me saying that the records of these persons in the screening committee were not found.
Then we are keeping it for hearing on 28th of May. Matter be listed for hearing and disposal on 28th of May. Whatever records you want to produce, you produce. Otherwise, we are passing orders. Yes. Here, Mr. Odhikari says the earlier order has been cancelled and a fresh order has been issued.
Yes,
I do not have a copy of that.
it has been served to him through Santos app, my lord. I'm
That
told.
14 February is today's. I did not have
Yesterday.
it. Yesterday, I did not have it, my lord. I'm sorry. Couple case.
Letter survives, my lord.
কি কইলে? Group center, Amity.
Same place.
Both are sent to group
Yes.
center, Amity. Yes,
Yes.
we agree. Noted.
Heard learned counsel for the parties.
In view of this order, my lord, lordship will close the writ.
In view of the learned CGC, Mr. Odhikari has placed before the court the amended transfer order dated 14/5/2024, whereby the petitioner and his wife have been posted at the same place, which is
Group center, Amethi, my lord.
Amethi.
Group Center, Amethi.
Yes, my lord.
Stop. The earlier individual transfer order of the writ petition from Group Center Guwahati to 60 Battalion has been cancelled.
Yes, my lord.
In that view of the matter, the learned counsel for the petitioner submits that nothing surprised in the writ petition to pursue any further, and accordingly the same may be closed. Considering the prayers made, the petition stands dismissed, closed, as disposed of as not pressed.
Problem.
Interim orders, if any, stand vacated. Copy of the modified transfer order is kept on the case record.
Problem.
Orders, I think 55.
You respected, my lord.
Why is it for orders?
Yes, my lord. It's for the file affidavit in opposition respondent number 5, my lord.
So they filed,
Yes, I have received, my lord.
okay. Are you filing any reply? Do you want,
No, my lord,
you're not filing?
not today.
What about the primary respondents, state respondents? They filed?
We have not filed.
Not filed, my lord.
You have not filed. Do you want to file? What is the issue here?
Those, my lord, the respondent number 5, my lord, is claiming this his wife, my lord. And now, my lord. And now, my lord.
It's between
There,
first
additional
wife and second wife.
Yes, I'm claiming I'm an only wife, not first wife. No,
You're
my
the
lord.
only wife.
Oh, yes, only wife.
And
And
who
now
is the-
respondent number 5 claim his wife.
Now, on what basis?
And now, my lord, their additional affidavit in opposition, my lord,
In
paragraph
the,
number
in,
2.
in your, in the service book, whose name is there as a nominee?
No, my lord, there's no name in, I have file RTI, my lord, I can reply, my lord. There's no mention in nominee, my lord.
Then? Who is to decide?
No, my lord. My petition, my lord. Here in a additional affidavit in opposition, my lord. Page 33, paragraph 2. May I read, my lord? That by answering the deponent, the respondent number 5, beg to state that she is the legally married wife of the late Pradeep Saikia, and her marriage was solemnized with him in the year of 2005 as per Hindu rites. Now, my lord, my petition, my lord, the respondent number 5 claim that marriage was solemnized in the year of 2005. Now, my lord, my son was, my lord, my petition, my lord, page 17, my lord. My son's date of birth, my lord, is mentioned here 1/1/1996. My petition, my lord, it is the Board of Secondary Education Assam, the registration card. My petitioner's son's name in Gitartha Saikia, and now, my lord, the son of my lord Pradeep Saikia and present petitioner Sunmay Saikia, my lord. Now, my lord, the date of birth 1/1/1996. My child was born on 996, in 996. And now, respondent number 5 claim the marriage was solemnized in the year of 2005, my lord. And now, my lord, dear additional affidavit, my lord, the annex, my lord, page 35, annex 1 is voter card, my lord. Voter card is mentioned, my lord. Husband name, my lord, Pradeep Saikia, my lord. And now, my lord.
Let us hear from the department file. What are the records available in respect of pension?
Doctor, when we sought for instruction, we have been forwarded documents and a cover letter telling us that there are 2 applicants and the fact that service book is blank, no name has been mentioned. And so this cover letter with the instruction says there are 2 applicants, both with certain documents claiming to be the wife. And the instruction is now, Lordship, asking for us to tell who would be receiving the pension as per rules. Now, Lordship, as per Assam pension rules and certain judgments of this Honorable Court, it has been held that the first wife gets the pension. But here, Lordship, the private respondent is disputing the existence of the marriage
No,
itself.
as per your department
Yes,
report, whose name is available?
As per our records, Lordship, there is nothing on service book. but both of them have submitted representation with documents claiming to be the wife. No marriage certificate.
None has submitted a marriage.
Marriage certificate. But the petitioner has next of kin certificate, and the petitioner
Where is the next of kin?
My lord. My petition, my lord, page number 22, my lord.
22.
22. Page 22, next of kin, my lord. And now, my lord. And my lord, the page 18, my lord, the miss case number showing so 125 CRPC is proceeding, my lord. This order, my lord. And page 20, my lord, page 20. Page 20, my lord. This is a judicial message first class. The notice, my lord, to the executive engineer. May I read, my lord? An order has been duly made requiring the above named Sri Pradeep Soikia, son of late Ratneswar Soikia, residents of Jhanji, Moransiga, Bhodolua Gaon, PO Moransiga, PS Gaurisagar district, Sibsagar, Assam, second party, to allow his wife, my lord, specific mention, to allow his wife, yani first party, for maintenance the monthly sum of rupees 3,500.
Yes. Who's for the private respondent? What is the basis of your claim?
Lordship, may kindly peruse, my lord, affidavit in opposition, my lord. In my lord, paragraph 4, my lord, page 28. I have specifically mentioned, my lord, whatever my deceased husband have told me that he never married the writ petitioner, my lord. He had some illegal relation, my lord. Lordship, may kindly peruse my.
How is that a matter of evidence?
Lordship, whatever documents, my lord, they have produced, my lord, nowhere it is mentioned that, my lord, Pradeep Soikia is her husband, my lord.
Oh, the next of kin?
Next of kin, my lord, I have filed an application, my lord, to cancel the next of kin
That's a
certificate,
different
my
issue,
lord.
but as on date it stands. What about the judicial order? This order of maintenance, although it does not establish, although it's
Payment of maintenance,
although
my lord, my respectful submission before your lordship, my lord, governed by two different sets of law, my lord. Payment of maintenance is governed by, my lord, under section 125.
correct, but then there is a finding by a judicial authority.
My lord.
That she is the wife and the amount of such and such maintenance is to be paid. So this is one evidence that the court, this is an order of a court. There is
That
no
I agree
occasion for
with
the
your
court
lordship.
to
Lordship, that
not
agree,
to rely on it.
But in
The
case.
fact, see,
Lordship.
this order can be used as an evidence to show she's the wife. Whether she's the first wife or second wife, this order does not say.
Lordship.
But at least it is apparent that she is the wife. This is the finding.
Lordship.
And there was a direction to pay.
Lordship.
Then this certificate, next of kin.
Next of kin certificate, my lord. Yes.
Then
I have
on what
filed an
basis are
application, my
you
lord.
taking a claim?
Lordship. But in my voter ID, Aadhaar card, everything, my lord, it is written that my.
It's a matter of fact, you'll have to go to a civil court and sort it out. You go to a civil court and file it. How, on what basis are you objecting?
Otherwise, my lord, we do not have any claim, my lord. She has also, except, my lord, judicial order, my lord. They have obvious, my lord. Yeah,
You produce any claim before the authority concerned, and if your claims are found to be genuine, the authorities will pass appropriate order. Otherwise, on these limited materials, the authorities will consider. What do you say, Mr. Bodhak? There is no nominee.
Lordship, going by the papers, there's a strong presumption that the first, even though the second marriage might also be a valid one and considered voidable, but the first marriage, there's nothing on record to show that the first marriage was ever dissolved, I would say, Lordship. And these documents are there, and the next of kin certificate has also been issued by the registrar office. So maybe private respondent may be given a liberty to challenge that document.
Up to them, if we are not foreclosing it.
Otherwise, Lordship, if
Unless you produce some evidence, it can't be helped. We are closing the matter. And you are for accountant general. Heard learned counsel for the parties. Anything to submit?
No, my lord.
A heard learned counsel for the parties. This writ petition is filed by the petitioner, claiming pensionary benefits in respect of services rendered by her late husband, late Pradeep Saikia, late husband of the writ petitioner. Where was he working? As a Khalasi. Grade 4. Grade 4 employee as a Khalasi in the Office of Executive Engineer, PHE, Sibsagar Limited. Stop. During his service, petitioner died in harness on 6/4/2023. Stop. Then a counsel for the petitioner has enclosed a copy of the death certificate. Where is the death certificate? Death certificate?
My lord, the next. Page 21, my lord. Page 21.
Includes a death certificate dated 12/4/2023 issued by the competent authority, showing that late Pradeep Hazarika expired on 6/4/2023, and the name of the petitioner was shown as the spouse of late Pradeep Saikia. So, pursuant to the expiry of our husband, the petitioner also approached the competent authority and has been issued a next of kin certificate by the Office of the Deputy Commissioner, Sibsagar. The further claim of the petitioner is that during the lifetime of late Pradeep Saikia, there were some matrimonial differences between the petitioner and her late husband, and that led to filing of a maintenance case before the competent board, and by order dated 10/10/2018, passed in Miss Case number 17 of 2018 under section 125 CRPC. The second party, namely late Pradeep Saikia, second party, namely the husband, was directed to pay rupees 3,500 into the account of the petitioner as the applicant. Stop. Further, the DDO / Executive Engineer PHE Sibsagar Division, Sibsagar, was directed to deduct 3,500 from the salary of the employees Pradeep Saikia and deposit the same in the bank account of the petitioner, Srimati Sonmai Dotto Saikia, on monthly basis within every fortnight. This order was passed on the compromise arrived at by and between the parties. So, Learned counsel for the petitioner therefore submits that the petitioner is the only wife of late Pradeep Saikia, and therefore her claims for grant of pensionary benefits ought to have been considered by the respondent authority. The same not having been done, the writ petition has been filed praying for appropriate orders. The standing counsel, PHE department, Mr. Rai Botako, submits that the department records does not reflect a nominee in the service book which was maintained on behalf of the petitioner. So he, however, submits that the next of kin certificate read with the order dated 10/10/2018, passed in Miss case number 17 of 2018 under section 125 CRPC, prima facie reveals that the petitioner is the wife of late Pradeep Vaidya. Mr. Your name, please.
S.A.B. Khabir, my lord.
S.A.B.
Khabir.
S.A.B. Khabir, learned counsel appearing on behalf of respondent number 7, submits that he has opposed the claims of the petitioner by filing an affidavit in opposition as well as an additional affidavit in opposition. So it is submitted on the basis of the averments made in the affidavit that according to the information given by late Pradeep Vaidya during his lifetime, he never married the writ petitioner, and rather he had married, he never married the writ petitioner, although he had some relationship with the lady. Stop. The learned counsel for the respondent number 5 submits that the respondent 5 had a lawful marriage as per custom with the petitioner as per Hindu rites and rituals. Stop. He therefore submits that she is the widow of late Pradeep Vaidya, and therefore it is her claim and not that claim of the writ petition that ought to be entertained in respect of pensionary benefits. Stop. MSD Montreal and its counsel appears on behalf of the accountant general. Having heard learned counsel and about careful revision of the pleadings on record, this court will be considered view that the writ petitioner, having relied upon the next of kin certificate along with the order dated so and so passed in Miss case 17 of so and so under section 22, prima facie has been able to satisfy the court that she is the legally wedded wife of late Pradeep Vaidya. So, although the order dated 10/10/2018 passed in Miss case 17 of 2018 was an order passed in the context of paying the maintenance to the petitioner. Say being a judicial order, it is a strong evidence to the fact that the petitioner has been considered to be a wife of late Pradeep Vaidya, and the maintenance amount of rupees 3,500 has been directed to be deducted from the account of late Pradeep Vaidya to be deposited in the bank account of petitioner. So, the next of kin certificate dated 18/5/2023 issued by the Office of the DC, Sibsagar, although although disputed by the respondent number 5, has not yet been withdrawn or cancelled by the Deputy Commissioner. So, under such circumstances, prima facie does appear that the writ petitioner has stronger evidence in her favor in respect of a claim that she is the legally wedded wife of, she is the wife of late Pradeep, she is the widow of late Pradeep Vaidya, and therefore entitled to the pensionary benefits. So until a competent court of civil jurisdiction passes such order, negating the claim of the writ petitioner to be the widow of late Pradeep Koike, the department is required to process the claim of the writ petitioner for grant of pensionary and other retirement benefits. So the department is therefore directed to verify and examine the claims of the writ petitioner as well as the respondent number 5. And if no contrary evidence or claim is noticed by the competent authority in the department, the department will proceed to release the claim of the writ petitioner towards pensionary and other retirement benefits as the widow of late Pradeep Koike. The respondent number 5 is at liberty to approach competent court of civil jurisdiction to challenge, to put a challenge to the claims made by the petitioner. Stop. In terms of the above, the writ petition stands disposed of, allowed and disposed of. Once the pensionary papers are processed, the same shall be forwarded to the office of the Accountant General, who in turn will forthwith release the claims of the, who will forthwith process the claims of the pensionary benefits as forwarded by the department.
Highly reduced.
It has time to disposal or abolition. Yes.
Post subject, fine.
For hearing item 53.
Here I have filed an affidavit to bring on record the minimum wages which are fixed by the government of Assam from time to time. That affidavit perhaps has not come on record. What has happened is that these people, they are being paid a mere amount of 83 rupees per day. The minimum wages act, the other schedules are much higher than that.
And your claim is against whom? The oil or the government?
The Assam government. What happens is we are VDP members. We are VDP members, which is supposed to be a voluntary service, but we are engaged with the oil to the Assam police to guard their pipelines and their oil wells. Stand of the oil is that whenever you engage someone with us, with the government, the deal is that whenever the government gives them the persons, oil on affidavit has stated that we will pay what the government asks us to pay them. It is the Assam government who is utilizing us and paying us 83 rupees a day.
Yes.
So therefore, my lord, the central government and the state government were included as parties to find out what is the minimum wage that should be paid to us. That is paid, my lord. We may not have other service benefits, but at least for the service.
Yes, Assam government was appearing. How can you pay 83 rupees in today's context?
Lordship, in respect of the challenging the clause 12 of the VDP Act, Lordship, they have filed already opposed this case, this honorable court, and accordingly the honorable court division bench is taking up the matter on, and 21 the matter next hearing days is fixed, Lordship. Because clause 10 is a bar to remuneration, Lordship. Yes, sir. Clause 10 specifically states that no member of the organization shall be entitled to any remuneration, but commendable services, including welfare work by any member, may be suitably rewarded as may be prescribed. Right. So now on 21st, Lordship, the revision yesterday the matter was listed, Lordship, and
Clause 10 of what?
Clause 10 of the I just clarify, my lord. It's very disheartening. There are two parts of the thing. One part is when I render my services as a VDP person, solely doing my voluntary job. I am not supposed to be paid anything. That part is under challenge before the division. Here our claim is the Assam government employs us
Not for
to,
VDP work.
not for VDP work, but with certain rules and regulations and a selection process to do certain work for the oil. And we want our remuneration for that particular job which we have rendered.
Why the?
Where is the connection? It is just an attempt to push away a case from today.
Why are you objecting?
Well, what is that? They have stated on affidavit, they are ready to pay us.
Expecting surveys, you are required to pay the minimum wages. Pay it. What is the state minimum wages, Mr. Council? State council?
My lord.
Lordship allows me that I can just put on the copy of the affidavit that we had filed, my lord.
You have brought it on.
We have got it on record.
Oh, okay.
Lordship,
Some other day.
therefore, Lordship, fix the matter after 1 o'clock, because in this case, we are lead by senior counsel as doctor.
We'll
Call for the affidavit, yes.
some other day. You
Because
get it
on affidavit, once they have stated that we are ready to pay whatever the government tells us to pay. That is the other,
You'll be what, unskilled?
or even if we are unskilled, it is still Lordship will find somewhere around 300 something matter. I have got the state government notifications. If I'm informed correctly, matter the central government, it is much higher. There will be two sets of notifications, matter. If we go by the central government notification, it will be much higher. What I've got here is a state government notification. In fact, matter the central government is a party. They were also required to have their instructions.
I have received instruction.
Yes.
I may be allowed to file affidavit or not.
What is the rate?
Rate is 832
Then
We are being paid 83, 10%.
why are you not doing it?
in Dulia Jania.
Then you pay them.
I may be allowed to bring it in.
This is inhuman, to say the least. You're extracting work, paying 83 rupees. By a Fortune 500 company like oil.
Now, question is for Lordship, whether these are the, these persons are.
See, you disengage them, and you employ your own people. Disengage them.
We have the employees, Lordship.
You
The oil
disengage
owns the CISF mines are their Lordship. But due to the local peoples, they are engaged, Lordship. And there is notification from the state government, Lordship, and in terms of the state government decision, Lordship, we are paying.
That is
That's all
exactly
right.
what is objecting to.
Anyway, let the affidavit come then.
Yes.
It is submitted by the council to the petitioner that an additional affidavit has been filed on record. However, the same is not available. Has been filed, and this, however, the same is not available on record. Matter be listed next week. Or you want it after 2 weeks? Listed after 2 weeks to enable the respondents to file any reply affidavit to the additional affidavit brought on record, stated to have filed by the writ petitioner. Matter be listed again after 2 weeks. 2 weeks. You give that copy back.